Good morning. Good morning. Good morning. Good morning. Okay. Let me handle this business real quick, y'all. You know what we're here for. You know why we're here. Good morning. Hi, friends. Hey, Rose. Good morning. Good morning. Good morning. Good morning. Let's see. So nothing's happening yet, but the feed is on. Nothing is happening. The feed is on. So we're just going to keep it very cute and Mayute until it's time. Uh-oh, McBurney's talking now. Hold on a second. The calendar is off the chain. Uh-oh. Okay, let me run this back just a little bit. When McBurney. I'm just running it back like a tad. And I'm gonna get off screen so we don't have any lagation.
To come back here. I don't know where work is for you, and I'm sorry for the inconvenience. I don't know if there's family here for Mason Washington either, but he's entitled to the bond hearing, and we will do it. We need him.
That's okay, Judge. I'll report to my other courtrooms and then I'll leave a number.
Okay, great. Yeah, just check back in. That'd be great. Thank you. And then I'm not sure who's here for Ms. Ford. Ms. Rios, your name is on here, but there are some other defense attorneys. Are you handling Ms. Ford's case?
I missed that calendar, but I'll just go back and talk to her.
Okay. It's a probation modification. She will be here. She's not here yet, but you're going to be here for a while anyway. So we expect her to be here. And then do we need to bring Mr. Mayo up? No. Okay. Did you hear that? So Mr. Mayo is good. He's here. He was busy and so couldn't come up when Deputy Gordon was doing all that. So Mr. Mayo will stay downstairs. And then for whatever reason, we brought Mr. Barber over. Remember which one of you took his plea? Yeah, he's already pled. Do you want it? It was a mistake in transportation. Do you need to see him at all? Okay, so Mr. Barber and Mr. Mayo are good to go, Deputy Gordon. All right.
So you can see Will sitting right there.
Let's get going with the trial calendar. So Mr. Compton is everyone else up? Yeah, everyone else is up. So Mr. Compton is here.
Court,
I think what we'll do after we get through the calendar, because there are going to be lots of lawyers who want to descend on Ms. Smith. She can go into the jury room and deal with those descendings. And we'll do.
What are we watching right now? This is McBurney's court. We've been watching a case for 2-3 weeks now. Kayla Brown, her co-defendants are in court today. Will is sitting right there in the first row, as you can see right there. I'll make it bigger once they actually pull the case that we're interested in. But for right now, I'll just kind of have it set back a little bit. So anyway, that's it. Oh, okay. Hold on a second. Okay. So yeah, we're in Fulton County. We're in Fulton County.
Mr. Compton's sentencing because Mr. Abadi's here and Ms. Wood, you're here. So we'll do that.
Good morning, good morning, good morning, everybody.
Position 2 is Mr. Charles, and Mr. Apt is on. I don't know if his client is on, but we've got some iPhones and stuff. Hey, Mr. Apt, can you hear us?
I can, Your Honor. Good to see you. Thank you.
Likewise, happy World Cup. So is Mr. Charles on the call?
I think I see him there. He's listed as meeting. I apologize. He doesn't have his name.
There he is. That's okay. It's all good. There he is. Mr.
So there's a lot going on. I don't know what all these other cases entail, so I almost am tempted to kind of put it to the back a little bit. But
Mr. Abadi gave me a just procedural update yesterday as I was asking him about his various cases on the calendar, and he flagged for me 2 things. One,
so let me just put this on mute for just a minute because he's calling the calendar, so we're gonna find out like what the order and sequence is of this morning. So let's see.
That he had been talking with you about potentially resolving the case. Tell me where we are from a defense perspective.
I mean, Judge, we are ready. And if we can get the case resolved, that would be fantastic. And if we cannot get the case resolved, I mean, we are ready, but I don't want to. I have a very good working relationship with Your Honor and with Mr. Abate, and I'm just not going to object if the state, you know, the ADA, I guess, left the office less than 2 weeks ago, and I'm, you know, I went into this profession so that there would be fair trials. I don't know how fair it is for.
Did Abadi leave the office
on a murder case in less than 2 weeks? But I'll do whatever the court orders me to.
Did he say Abadi left the office? What?
To do, of course.
And
I'm here ready.
Name's Jones.
Not objecting to
Tequila Jones and Adarin Jones.
To resolve the case.
Okay, and it's that last bit that I wanted to drill down on. I appreciate your professionalism with this, and because your client's on bond, even though these are really old charges.
They're on the docket for today. If you're looking at McBurney's docket for today, Jones.
There is, of course, less pressure to say we've got to absolutely do this one, given the change on the state side. But there's balance to be struck, and closure is due to your client and to the deceased family in this case. Where are you and Mr. Abadi still talking? Or I just want you to put a more of a gloss on it, as in like, we're still pretty far apart, but maybe the state.
Oh, okay, so Mr. Abadi is there. He said somebody left the office, but I don't know who it was.
We'll get more realistic.
Or maybe someone left and he took over.
I need to get my client in a headlock for a little while to work this out, or where
we are still talking. I have I don't know. I almost hate that we're on the record, but I know Mr. Bate's not here, but I would.
He is. He's sitting in court. You just can't. You can't see him, so don't say bad things about him.
No, I never. I would never do that. He's fantastic. So I guess I'm going to talk to Mr. Abate. We might get it resolved. If there's, I'm again, this is a very selfish request, but there's another judge in another county who's trying to leapfrog, and Mr. Charles' case is older. So if we can reach a resolution, I'd still like to call it for trial on Monday and then resolve it on Monday, so I can sort of dodge that other case. Mr. Charles' case is older. But
I hear you. That's one of the issues we've got, is that it's older. Well, I'll tell you what I'm going to do. I will leave this on the maybe we'll get to it list. You and Mr. Abadi keep talking. If you all sort out that it's a resolution, next Monday would be a great day to do that. That might work for everyone. Remind me, Mr. Charles is not local, and so if he's going to be involved with a resolution or a trial, he needs to be here. And I want to make sure he has enough notice to get here. But not that he doesn't have to buy a plane ticket that then he doesn't use.
Well, if we can't, I understand that, but I'm hopeful we'll get it resolved, and then we could do that on Monday. And then if not, and the state wants to, ask for, whatever continuance, then on Monday they will, and so be it.
Okay. Mr. Abadi, anything you want to add to the mix?
No, I mean, I feel very confident that we'll come to a meeting of the mind.
Okay. I don't know if you could hear that, Mr. App, but it was positive words from Mr. Abadi. He said he felt very confident that you all would come to a meeting of the minds. So keep the channels of communication open, and I will bug you two from time to time during the rest of this week so we can see what Monday is lining up to look like. Okay.
Okay. So, but for now, I am to report on Monday.
You should assume for now, but I will get an email out later this week saying, here's the order in which we're going to try to do things on Monday. There are, unsurprisingly, other moving parts, and it may be that there's a case where someone's in custody, and we are for sure going to try that on Monday, and then we'll just have to figure out another time to bring this one to the front of the line.
I understand. Thank you, Your Honor.
Okay. Mr. Charles, do you have any questions about what we discussed?
No, I don't.
Okay. Stay in touch with your lawyer. He'll get you an update soon.
Thank you,
Take
Your
that
Honor.
as an okay. You two are free to go.
Thank you, Your Honor. Good to see you. I'll
Me
call
too.
you out.
Mr. Charles is looking clean.
Jose Lopez.
I wonder what his situation is. We might have to look that one up. And it sounds like he has multiple cases, so I don't know.
We've talked about that. Any change in that, Ms. Wood?
Okay.
Okay. Do you want Mr. Lopez to come out today?
You can go to the door.
Okay.
That's okay.
Does he need an interpreter? Okay, great. Can we bring Mr. Lopez to the door, please?
Why don't I see Michael Abadi? I see Will.
While we're waiting on that, Dwight Foster is a plea.
I need to speak with
You need to talk with him. Okay. Thank you. Good morning, Mr. Lopez.
Morning, Judge.
Hey, I just want to give you an update on your case. Your case is on the trial calendar. I'm not sure we're going to be able to reach it, this trial calendar. We're starting a trial on Monday, and we've got a bunch of cases, and there are lots of moving parts. The state has asked for a one-time continuance so that they can get their situation prepared. Ms. Wood, your lawyer, has said, hey, we're ready. We are ready to go to trial. So this is not Ms. Wood saying we need more time. She's aware, and I'm aware, that you're sitting in custody. So I will see where this shakes out, but it's possible we don't get to your case on this calendar. It will move to the very next trial calendar, and it'll just move higher up because it's an older case. And you've been in jail now for about half a year. So I can see your face. And so it's time for this to be resolved one way or the other. The state puts up the evidence and the jury decides, or maybe the state comes up with a different offer that you and Ms. Wood find to be more appropriate. Okay. I just wanted you to hear from me what the plan was. Ms. Wood is pushing to get this thing heard. Okay. Appreciate your patience. All right. Dwight Foster, Ms. Wood, he will speak with, and it may be a plea. He was re-indicted, or he has two cases? Re-indicted, and they're both on the calendar.
Yes, and the state would obviously not cross the original indictment.
Got it. Okay. Kenneth Newton has two positions, and I think those are pleas, or you need to talk to him too. And is that more likely a plea than Foster, or you need to talk with these folks?
That's more likely.
Okay, great. Ms. Solange is pleading tomorrow, so hopefully she's not here. Nope. Okay. Robin Johnson. Hi, Ms. Johnson. Good morning. I have this as a likely plea.
Yes, Judge.
Need to chat with Ms. Johnson?
Briefly, Judge.
Okay. So Ms. Johnson, we'll take care of your plea probably this morning. We usually do the pleas for people on bond first so you can get on your way, and then we bring the other people out. But the deputies may need me to do it in a slightly different order, but we'll certainly take care of it today, okay? All right. Ms. Wood will talk to you in a sec. Sit tight. Joseph Varner should be in custody, still likely a plea?
Yes, Judge.
Okay,
Both cases.
both cases.
Yes.
Is he on a supplemental or he's just not on the calendar?
Don't think it's on the calendar, but I can give you the number when you're ready.
I'm ready.
26.
Okay, so no, you're not late. You're right on time. Anybody is in until you see Will Wooten, you haven't missed a thing. We're just sitting and listening. We're sitting listening. It's a full packed house. I checked McBurney's roster yesterday. I probably should pull it up again just for a little visual aid. And I was like, gosh, they get through a lot in a day, but you know what I'm saying? That's what they do. So everything doesn't take a long time. Some things just take 5 minutes, literally. So I don't know, but they have a packed calendar. But we see our the prosecutor for the case that we are waiting on sitting in the back. So until we see him come to the front, this lady right here sitting in the front with her hair down, and then there's another lady at that's the prosecutor's table right there. So Will is still sitting in the gallery. As soon as he moves forward, baby, it's showtime. Okay.
SC 002.
Okay, so I like to get the case numbers, that way if it's a case we are interested in, girl, we can go be nosy and go look it up. So I'm gonna try not to use the back button because this is it's live right now, and we're just a little behind, like 5 minutes
Supplemental
behind.
or you just
So I don't want to mess with it too much, but yeah, they're basically calling the calendar at this moment, so nothing has really gone in depth.
not on the calendar?
Don't think it's on the calendar, but I can give you the number when you're ready.
I'm ready.
26 SC 002659.
Okay, let me do one thing. We have a court reporter on. Ms. Allen, can you hear us?
Yes, Your Honor, I can hear you.
Good morning. Thank you for being here. I will let you know when we need to be on the record. So you're welcome to take down whatever you want, but I'll be clear when there's something for which we definitely need to make a record, okay?
Thank you, Your Honor.
You're welcome. Travis Nelson is here. Good morning, Mr. Nelson. Ms. Wood, you had indicated possible plea?
No, Judge, this is the one where there was a diversion offer on the table.
Okay, possible diversion.
Right, so I just need to speak with him once more.
Got it.
He can be ready if it doesn't resolve with diversion.
Okay. I didn't mean to put it in the wrong category. So Mr. Nelson, Ms. Wood told me yesterday that you right now are in a situation where either you're going to accept diversion, whatever that means, and Ms. Wood will talk to you about that. That's as low as the state's willing to go. They're not going to just make the charges go away absent this diversion piece. If not, Ms. Wood has said she is ready to go to trial. I think the state has said the same. So you might be one of the ones who comes back on Monday, see if we get a jury for your case. So but talk with Ms. Wood. We're going to pivot to a sentencing hearing in a little bit. Oh, but that involves Ms. Wood. So she will talk to you in a little bit. Okay. All right. Mr. Brown already pled. So did Mr. Reeves. Jason Bates. Hello, Mr. Bates. Hello, Ms. Cabrera.
Hello, Judge. I have a recommendation from the state, so I need to convey that to him.
You'll talk with Mr. Bates. Got it. So, Mr. Bates, you and Ms. Cabrera will talk. If we've worked something out, we'll take that plea today. It could be negotiated, it could be non-negotiated. And if not, then we'll talk about whether this is something that needs to come back on Monday. Okay. Before I implicate you on Monday, do you have conflicts next week or leave?
I start, so the next 2 weeks I have leaves.
Oh, this is one of the reasons why we didn't put like the Amari Williams case. And
So I have leave that starts this Thursday and runs through Monday, and then I'm back in court for like 2 days.
of course you do those types of leaves, right?
Yeah, another one is like Thursday.
Friday through Monday, these trial proof leaves that you take. Like, I'm not gone. I could be here on a Wednesday for those 1-day misdemeanor trials.
But yeah, that's the only real weird leaves I have all summer.
Well played. Okay. Well, you've got permanent leave for me, sadly, July 1. So we'll see if it's a plea with Mr. Bates. You guys talk and then let me know. Okay. We'll see. All right. Ms. McClarity and Mr. Walker have resolved. Mr. Ramirez Perez has bumped to an inquiry calendar next month. Mr. Barber pled, although he's here. Mohammed Dumbuya. Good morning, Mr. Lang. Good morning, Mr. Dumbuya. I don't have you listed in any category from my brief conversation with the prosecutor. Do you need to talk with Ms. Smith this morning or yes? Okay. Once we get through the calendar, as I mentioned, I'll be doing a sentencing. And so Ms. Smith will go into the jury room and you should go in there and then you guys can let me know what the plan is. Just to repeat, if this isn't working out today, then we all need to be together on Monday for a potential jury selection. Okay. All right. Thank you. Laura Charles. Hi, Miss Charles. Ms. Wood told me she is ready to go on this one to defend you at trial if that's where it's going. And the state has announced ready when reached, meaning we put it in the line and see where we are. I'm going to encourage Ms. Wood and Ms. Williams to talk one more time. It never hurts to have a conversation. But Ms. Wood let me know that this is one that could well be a trial. I need you to sit tight until Ms. Wood releases you. You don't need to hear from me again unless we're working the case out and then we'll all have a conversation. But if Ms. Wood gives you the green light, just know that you may need to come back on Monday. I'll be letting her know soon enough, and then she'll communicate with you saying, we're not getting to your case, or yes, we are. Okay? I don't know about perfect, but that's the situation. Yeah. All right. Kanye Willingham should be in custody. I don't see Mr. Melnick. So Ms. Nelson, if you could get me an update when you get a chance about Mr. Melnick's whereabouts. Thank you. Alex Blue in custody and we're re-indicting. So we'll see what happens with that.
Judge, I just wanted to make an announcement on the record because we have the victim here. She
Oh.
was the person last time that filed plea hearing.
For which of Mr. Blue's cases?
Position 22.
22.
Yes,
This one with lots of, we have a victim here.
one of the victims.
One of the victims.
Yes.
Okay.
So I had a conversation with her last night to let her know that the state will be re-indicting and no process to re-indict. She understands what's going on. However, I did tell her that I would make a statement on the record while she was here in person.
So you would make that statement.
Correct.
Okay. Who is the person that were right there? You two of you here. Okay. Hey, good morning. Ms. Smith shared with me yesterday the mistake in the indictment, that there are a number of people named who weren't victims, and there are some who were unintentionally omitted. And so the state wants to re-indict the case so that all of the victims are included, which is how it should be. You two are both victims. Are you already named in it, or are one or two of you ones who need to be added back in?
One is named and one is not.
One is not. Well, that is going to get fixed. I don't know exactly when that'll happen. I think the grand jury is not here this week, so it may be next week. And then we have to rearrange Mr. Blue. That's a quick process. It doesn't sound like it's a bunch of new evidence in the case. If there were there's not new evidence. Okay, so it's just the DA's office reconnecting the dots from the evidence they already have so that the proper victims are named in the indictment. You should not worry that this notion of, hey, the case is being dismissed is going to mean that Mr. Blue gets released from custody. That will not happen. And the fact that a case is being dismissed doesn't mean some favorable disposition one way or the other. In fact, the state really doesn't need to dismiss these indictments. They just need to get new ones. Once the new ones are in place, I'll probably press them to say, why are there two indictments? naming you all as victims. And then Ms. Smith can say, well, you can dismiss the older one. But typically they leave the older one in place, get the new indictment, and then they ask to have the older one dismissed so there are charges in place. And it just so happens, bad series of coincidences, there was a mix-up in Mr. Blue's other indictment that doesn't involve you all, and the state is fixing that as well. So I was hopeful we could try him on one of these this coming Monday. But he's, of course, entitled to a copy of the new indictment so he knows what the new charges are. I don't think they're going to be a surprise to him. His lawyer already knows this is coming, but we need to make sure we follow due process so that ultimately, if there is a conviction, it's one that's more likely to be upheld if there's an appeal. So I appreciate your patience. You're probably wondering why.
Okay, sorry, my mic wasn't on. I just pulled up McBurney's docket for today since, well, it looks like it's gonna be a minute. So if he's going, I think he's going in alphabetical order. They were just talking about Alex Blue. We saw, can y'all see this? Hold on. Yes. Okay. Let me make it bigger. Okay. So he's talking about Alex Blue. We saw the man in the car with his attorney, on the Zoom, Mr. Charles, maybe it was as Ragnaldo or Ragnald Charles. They're talking about some sort of re-indictment for Blue. Let's see. This is all for today. These are the cases of interest that we are interested in right here. Okay. The reason why I'm bubbling this up really quick is because I happened to notice at the bottom of the calendar, if you remember 2 weeks ago, Dontavius was on here. I think he is a Will Wooten case too. This is the guy that we just happened to look up his case. I don't know anything about it, but I think this is one of Will's cases also. Girl, maybe not. Because look at it's murder. Normally he doesn't handle stuff like that. But this is the guy I think that was trying to change his name to Sean Carter. And they, it was just random that he had a name change put in. And he wanted to change his name to Sean Carter. And then we just kind of, we just went about our business. But he's on the calendar again today. So I don't know what's happening with this. But I just happened to notice if you go back from when we first watched the proceedings, the Kayla Brown proceedings, 2.5 weeks ago, he was on the docket too. Okay. Anyway, let's get back to the reading of the docket. Let's get back because we'll be more than 10 minutes behind.
I wasn't this right in the first place, but there are lots of moving parts in these things. And it sounds like Miss Smith has caught that.
Girl, it was the changing your name to Sean Carter for me, but okay.
And it's going to fix it. Do you have any questions?
No, I did it yesterday.
Okay. I bet she was very thorough. You both are welcome to stay. Do we need to bring Mr. Blue out? Okay. So I'm gonna have him come to the door right now. When I'm done talking with him, we're probably not gonna talk about that case again today. So you both can stay if you want to watch what else is going on. But if you're ready to go, when we're done with that conversation, that'll be it for his.
I'll make the docket into a PDF real quick. Sorry to interrupt again. I'm going to make the docket into a PDF real quick, and I will drop I'll put it on Google Drive. And if you want to follow along on the docket, it's not going to be live with active links. The links won't be active, but at least you can follow along with the names if you would like. I'll do that right now.
2 cases. All right. Can we bring Mr. Blue to the door, please? While we're waiting on that, position 24 was a plea. Ms. Wycliffe was pretrial diversion. And then we'll talk about Godfrey in a second. I'm not going to miss that lock. That's going to be A-okay. Mr. Blue, good morning. I'm all right. I just wanted to give you an update that you've probably already heard from Ms. Wood, but I always think it's important for a defendant and a judge to connect each time he or she is brought over to the courthouse. You were brought over because today is the day we're calling a pretty lengthy trial calendar, a bunch of cases on it, some older than yours, some newer than yours. And yesterday, when I was talking with your lawyer and the prosecutor about, hey, which of Mr. Blue's cases could we take to trial? It was shared with me that there were some mistakes in both your indictments. And one of them, there were some people named as victims who weren't, and some names left off. And when I say victims, these are all allegations. I'm not saying anything is etched in stone, but the state wants to re-indict one of your cases to remove a few people who they contend are not victims, and to add in some names of people who they contend are victims. Your second case, the state wants to add a charge relating to your status as a convicted felon. And so they're actually re-indicting both your cases. You're entitled to be arraigned on both those. It's not going to be anything new. Ms. Wood is well aware of it. It's not a new set of evidence or anything. They are just wanting the state to revise these indictments, and they're going to get that in front of the grand jury. I think you said next week, Ms. Smith?
Yes, June 22nd.
Okay, next Monday. Once those indictments are in place, we'll get you back here or it may be that you and Ms. Wood talk and you say, I don't need to come back for arraignment. You can waive my arraignment. Could we just get into court for a trial? We can get right back in line for the trial. We just need to get those two new indictments in place. Okay?
I ain't even gonna lie, sir. I'm asking about what's going on with the new indictments and which cases are y'all speaking of?
So,
Girl, multiple case problems. Girl, when you have multiple cases, my Lord. Okay, I'm dropping a link to my Google Drive. It's a safe link if you want to click on it to see what's on the docket today in McBurney's court. It's there. I'll pin it. If you feel like you need it. If you don't worry about it. I just did it because sis had time. Okay, sis had time. And that's it. That's all. Okay.
I didn't mean to be unclear. Let me be more clear. Give me 1 second.
Yeah, Alex Blue actually has two
I'll be
cases on
more
the
specific,
docket,
and
as you
hopefully
can
that'll
see.
help.
Girl, what are they? Let's see. Let's.
Here we go with one.
Possession of a firearm, simple battery, aggravated assault. And then he's got
So in one of the cases, Mr. Blue, you are charged with
a lot of shit. Lots.
Here it comes.
Girl, terrorist.
On November 27th of last year, so around about Thanksgiving, you were charged with shooting at Ms. Lowe, Mr. Mitchell, Ms. Ware, Ms. Stewart. I think
Your Honor, the defendant waives reading of the allegations.
it's a Ms. Logan, a Ms. Booty, B-U-D-Y, and possessing a firearm, et cetera. So something that allegedly happened on November 27th of last year. That's one where some of those names I just read, the state is saying they actually weren't shot at. It was different people who were shot at. So they are substituting
Not
the
Ms.
names of the
Booty.
people who were the alleged victims. I don't have those names. Ms. Wood will get them to you, and you guys can
Oh.
parse through, like, how do you get that wrong?
I see Mr. Abadi right over there in the corner, like you guys said.
What's going on there? More importantly, if you are saying, I have no idea why someone is saying that I'm indicted for shooting at people, not hitting them, but shooting at them around Thanksgiving of last year, you and Ms. Wood should talk more. That's one of your cases. Ms. Wood, should I stop?
I just remembered something, so, the order that you just signed so that my investigator can bring the discovery to the jail to show him that we just received.
Yeah.
She's got an appointment this Thursday, so she'll be out with the lab.
You will get a whole lot more information, Mr. Blue. Ms. Wood, did a good job of getting me one of these orders that allows a laptop to come into the jail so you can watch video footage, body cam footage, etc. Anyway, that's one of your cases. And today's,
Yes,
and this
that's
is not the
Wooten.
forum for,
We are here to watch one of Wooten's cases, but they are still calling the docket, and baby, it's long. Okay. If you want to know what's on the docket today, click the link that I pinned up top. But the cases of interest to this court of public opinion is Jones, and we might stick around for Mr. Dontavius. Okay. Monsieur Dontavius Wright, to see what in the world. Oh, it's a murder trial, girl. That's not happening today.
you to say, well, let me tell you, I wasn't there, that you should just listen to what I'm saying. And then you can have 100,000 questions for Ms. Wood, and she will do her best to answer them. Your other case charges you, is an old one. It's not actually, it's just 1 month earlier. So just before Halloween in 2025, you allegedly shot at a guy named DeMarcus Beauford. And the only thing they're changing in that case.
Look at the prosecutor bobbing her head up and down. Hold on. Miss Ma'am, is that
state is you're charged with shooting at Mr. Beauford. You're charged with having a gun when you did that, of course. And you apparently punched him in the face. They didn't include the count that if you did all these things, you were also a convicted felon at the time, which is a separate offense.
wow.
So one is a shooting on October 28th where you supposedly shot at Mr. Beauford. The other is a month later, November 27th, you supposedly shot at some other people. Those are the two cases. The state's changing one just by adding that count, possession of a firearm by a convicted felon. It's a status offense. The other one they're changing because some of the names shouldn't have been in there. Those people weren't shot at, but other people are saying, no, I was shot at. And they're going to get those names in there. Hopefully this will become clearer later this week when you get to see the discovery that the state has provided. Those are the changes the state is making. Did me getting a little more specific help, or are you even more lost now? You're going to wait to see the stuff. This way, you at least you know what's coming.
Quiet,
it's not
sir. Keep
like
quiet.
it's a brand new case. It's these same two situations. And the state is just changing how they are going to talk about those two situations. All right.
Just to add clarification, there's that third case. Ms. Smith and I have been working
Third
very
case.
hard. It's unindicted,
Okay.
and it's related to one of these cases.
The Beaufort case or the many people case?
Yes.
The many people
And
case.
so one set of discovery was coming from Fulton Sheriff Department, and the other was coming from APD, and there was large costs between the agencies. So I explained that to him last week at the jail. Ms. Smith got it all together for me last week, and that is what we'll be reviewing this week.
Great. Okay. All right.
Really quick, I'm sorry.
No, it's okay.
I was saying that, or I just want to clarify that when we re-indict the many people case, one of those indictments, the language will tweak a little bit because one of those victims was shot.
Was hit. So it wasn't just shooting at. So we're going to have in the indictment, and John Doe, with the actual name, was actually hit on November 27th.
That's correct.
Okay. Got it. Okay. Still aggravated assault. It's just one that has a very different tenor to it because the allegation is that that person was actually struck by one of the bullets. Mr. Blue, your lawyer and her investigator will talk with you more about that. I just really wanted you to understand, like, why were you brought over today, and why is it that you're not going to trial next week? You're not going to trial because the state's re-indicting, and we'll just get this on another trial calendar. The unindicted case, are the charges less serious than these? Okay. All right. Okay. So that'll catch up. That's not something that we need to wait on because these are the more serious sets of allegations. Do you have any questions for me? Okay, that'll happen. We'll keep you up here so she can come back and talk to you, okay?
Y'all think everybody sounds like Nesto. Why is Wooten not sitting
Mr. God.
with the other lawyers? I mean, he might be. I don't know if the person sitting next to him is another attorney or not. But it looks like the table is full. I don't know that he's prosecuting with these ladies. And I guess, girl, he might be back there watching us in the chat. Who knows? He might be texting or doing whatever he does. He might have just needed some room.
Free. I don't see Ms. Nix, but that doesn't. Well, she's online.
Good morning, guys. Tap in as you come in, tap in as you come in.
Morning, Judge.
Hey, Ms. Nix, how are you?
I'm all right. How are you?
I'm well, good to see you. Ms. Wood shared with me yesterday that the DNA results are done. Good work getting those done. You committed, or they committed to you, they'd be done by this time. But now the rub is that the person who got them done is not available until July.
That's correct, Judge. So I do have some issues with witnesses. However, since Mr. Godfrey does have some other cases, if we do get to him in the list, the state would just move forward with one of his other trials.
That's you volunteering Ms. Smith to try a case instead of you trying a case?
Well, we did discuss that before, and I would try it with her.
Oh, you would do it. Okay. Well, Ms. Wood and I talked about that a little bit with Ms. Smith present yesterday, and I think most people's preference is that you're...
Nesto's almost become a catch-all. I got you, boo. I concur. It's just funny. Nesto is somewhat of a scammery fraudster catch-all. Okay. He has become somewhat of a little bit of a urban legend. So he fits into so many scenarios, right? That's what it's giving.
Well, I'm going to call your case the rape case. It will be the one, if there's going to be a trial, it'll be that one, but it cannot be.
Y'all, this live right here might have to just be, and then once they call the Joneses, I might just make that into a separate standalone Kayla, you know what I'm saying, continuation of Kayla codefendant. So just so you know, this might just be like whatever it is, because baby, I feel like we go, you know, McBurney, you know, I was looking at his bio. McBurney is a Harvard undergrad and law school grad. If that tells anybody anything, sir is superly duperly smart at, you know, top tier university, undergrad and law school. Let's see. Okay. Yes. Okay. Let's keep going out.
Next Monday.
Be here all
and
day.
Ms. Wood wasn't opposing the continuance. When I asked, she said that the DNA results weren't necessarily bad news for her client. And she would prefer, rather than everyone stipulating to whatever the DNA results were, her preference was to be able to engage the DNA expert in front of the jury about the significance of the findings.
Yes.
Okay. So I think the plan is that we don't reach Mr. Godfrey's cases. I guess I reserve the right to say you got to go forward with the ag assault or something like that. But that seems inefficient given that there's this charge that's a whole lot more serious. So we'll see, but I will keep you posted. And you're done with your leave by next Monday?
Yes, sir.
Okay. Did you have a nice leave?
I'm still on leave.
Okay.
It has been nice.
You are having a nice leave.
Yes, sir.
Thank you for joining us from the leave. You are free to go.
Thank you, sir.
Do you want to have Mr. Godfrey come to the door?
Just briefly, Judge.
So you said that about Mr. Blue.
Mr. Godfrey.
So McBurney sounds like when you are getting on a flight and they're like, welcome everybody. We're going to be flying at a high. We're going to be at a 25,000 altitude. The weather looks amazing. If you look out the left side of the plane, we are going to be going over Palm Springs and we're going to be in cruise control and we'll be landing in Houston by 2:30, maybe sooner if the winds are in our favor. Like he totally gives pilot vibes.
Will he understand that he's been charged with things?
He already knows.
Okay. Mr. Blue seemed to like,
Our
what?
flight attendants will be moving about the cabin and have a safe flight. And I'll be talking to you guys a little bit later.
Here. You shot at all these people.
He decided to. I think Will is sitting there
So-
reading the chat. Hey, Will.
I let her go. She's going to other courtrooms. This is the lawyer for the bond hearing we had, where we got the wrong Washington.
He was
So
nosy.
we just need to give her.
What?
Yeah.
Did he say, but I'm doing my job?
So Mr. Melnick will be here in about 40 minutes.
Do you guys remember Mr. Melnick from YSL? And he was Woody's lawyer, and he was going on vacation, and he got Kayla Bumpus to cover for him, the infamous Kayla Bumpus situation. And then I don't know what happened with Melnick, but somewhere during YSL, Sir got his license suspended for like 6 months. Sir, okay. Every time I hear Melnick's name, I'm like, sir, are you good? Like, did you get everything back squared away with the, I'm assuming he did because he wouldn't be at court, right? But he was suspended for like 6 or 9 months. He had some sort of drama with the bar.
Does he know about the DNA?
He was YSL Woody's lawyer. And because he had his very important vacation, we got to meet Kayla Bumpus.
The results. Oh.
Kayla, Miss Jackson. Miss
Hey, Mr. Godfrey.
Jackson, if you're nasty.
How are you? Good. I just wanted to give you an update since we brought you over today. I had your cases put on a trial calendar, and I was hopeful, since you've been in jail for a year, that next Monday we could start one of your trials. You've got one case with a real serious charge, and then two cases where they're less serious. And everyone is agreeing that the one with the most serious charge is what ought to go first. Ms. Wood shared with me that recently there were some somewhat favorable crime lab results, favorable for the defense. The expert from the crime lab who generated those results is on leave and wouldn't be available next week. And so what we talked about was then moving your case to the next available trial calendar so we can get you that trial date when we can get the expert here as well, rather than forcing your team to go forward without the expert. It sounds like it's important to have the jury hear from that expert about the significance of
Mr. Quixote Godfrey, Mr. Quixote Rodriguez Godfrey, girl, he's got 3 cases, one of which is a sex crimes case, and the other 2 are general complex crimes. Now that is giving some Nesto, because that's exactly what Nesto got going on. Baby.
DNA results. And so I agreed with that. We may, I don't think it's likely, but I want you to be surprised if you come back over here on Monday. One of your cases involves the allegation of aggravated assault and cruelty to children. We might try that instead, but the other case is so much more serious. That's the one that if you're found guilty there, the other cases will resolve. If you're found not guilty there, the other cases would likely result in a plea, given how long you've been in custody. So it seems a whole lot more efficient to try the most serious case. All right. Hopefully I'm not telling you something you have not already heard, but I wanted us to connect since you got brought over here. Do you have any questions for me? Would you like Ms. Wood to come back to talk to you? Or are you ready to go back? Yes, talk to you? She'll do that. All right, we'll keep you up here. You're welcome. Same with Mr. Comer. Do you need him brought to the door?
Yes, sir.
Okay.
Y'all, why am I throwing the docket into Excel? I'm like, you know what? I think I just need to throw this in Excel because this is ridiculous. I think Excel will keep.
Gosh, he's been in custody for a long time.
Active.
Does he know about the severance? We don't need to go into the severance. Okay.
He'll be fine.
Famous last words.
Coleman.
Over.
Comer.
Yeah, I'm here. Hey, Mr. Comer, how you doing?
Going good.
Good, I'm doing all right. So I wanted to give you an update since we brought you over here today on your case. Your lawyer filed a motion a while ago saying, hey, you can't, it wasn't that I can't, but she moved to, you're charged with 2 different murders. And Ms. Wood has said it's not legally proper or correct to try Mr. Comer at the same time for both murders. And you were here when we had that argument, and the state said, yeah, we can do that, and you should do that. I entered an order just a few days ago agreeing with your lawyer. So the state's going to need to try the murder separately. But that's throwing them a little bit of curveball because I just entered that order. So they're getting their witnesses all together, but we're not going to be able to do one of those trials on Monday. The state gets to pick which one it's going to do. And they'll let obviously Ms. Wood know. So we'll know if it's the trial that involves a situation with your mom or the other one. But the state will say, we're going forward with this one. Ms. Wood will let you know that. And then that'll be what we try. We'll see what happens with that. Depending on the outcome, it may be the other half goes away or is resolved. It may be that you end up with 2 trials, but you will not be tried for both murders together. Okay? Ms. Wood's going to come back and talk with you real briefly in a minute. We just got to get through the calendar and she'll talk with you and then we'll get you back to Rice Street. Do you have any questions for me? Okay, good seeing you. Jerron Reynolds. Still ready?
I'm going to talk to my new auditor, and so it might be resolved today, but I haven't been talking about it.
Okay, great. Let me know what we do. Auburn Johnson. Hey, Mr. Johnson. Your lawyer, Mr. Jones, is he en route? What did he tell you?
Conflict, you're getting another case, another county.
Okay.
And he's supposed to just be here for kids.
Okay, we'll check with him and see if we can get an ETA. So you know, he is very studious about that. So he's not going to skip this. A little surprised we didn't hear from him about the conflict. That doesn't mean he doesn't have a conflict. Okay, we'll look. Sometimes those filings don't make them all the way to us, but we need to definitely talk about the case today. So we'll hold for his report. So we're not going to bring Mr. Mayo up, Ms. Rios. You're still okay with that? Okay. Then that gets us to Ashley Chambers. Ms. Chambers?
Ms. Chambers is online.
That's right. We gave the green light and it's going to be a plea.
It is a plea, it's a prorated plea.
Okay. All right. And then Elijah Thomas. Hey, Ms. Tembeka, how are you? I'm well.
Okay, I just threw it in Excel if you want to know the charges, because I don't think the PDF I made showed the charges, but the Excel document does. It'll expire tomorrow, but just click on it and then expand it how you like, so you can see. But my God, I'm just like, there's just too many people. And then he's bringing up all these charges. I'm like, what's going on?
We will bring him out in a little bit at a minimum to work through the Jackson Deno, as in, do we need to have a hearing, or is it one where it's all on tape? So Judge, you can review the tape and we'll make our arguments or whatever. It may be that you and Ms. Smith are still talking.
We are, Judge, at this point, pre-trial negotiations are still active. I do believe they will yield positive results for the resolution for the trial. However, Judge, there is an outstanding discovery. I've already spoken to the state about it, and the state is just waiting on the agency to send it over.
Yeah, Ms. Smith helped me understand that I guess this was Roswell and Sandy Springs, and I remember it was a car and people are driving the car everywhere, and so there were 2 jurisdictions. And it sounds like Ms. Smith is working on getting you either Roswell or Sandy Springs, whichever piece you don't have. Okay, got it. Well, we'll certainly work through the Jackson Deno piece today. Thank you. And then we have a supplemental calendar. Mr. Foster, we already talked about. Ulysses Greer.
So this one is mine, Your Honor. We had some
Roswell.
report. So he got put back on the calendar after that.
Yeah.
I do have the state's recommendation, but will he be ready to move forward for trial right now? No. So it's kind of a not a surprise placement on the calendar, but he was placed on the calendar since he was clear.
I think that exactly. When we got the results, we said the next spot is a trial calendar,
And
which
that's
is,
when you jump back on.
yeah.
We're not ready, but we're ready to get ready.
Okay.
I do have a recommendation.
So you all will talk and then let me know.
Yeah, I just don't anticipate there being any resolution as of today, and so I would ask that he be placed on another trial calendar after this, and that the recommendation that was given by the state, that he still have the opportunity to do a negotiated plea, if that's something that he chooses to do at the next calendar date.
So he's not had his final plea because we
We would
paused
it,
things.
right.
Okay.
We made it to a calendar, but then
Yeah.
we had some things that we needed to do, and so those results will come back in.
Yep.
And so we're kind of picking up where we left off.
Got it. Okay. Well, let's see where we get today. And then you can let me know. Thanks. And on our second supplemental calendar, we have Ms. Jones, who I think I see in the back. Hi, Ms. Jones.
Okay.
And what about Mr. Campbell?
I've not heard from him this morning, Judge.
Okay.
I conveyed a new offer on Thursday last week. I have not heard since then.
We will reach out. But I'd ask you, Ms. Jones, to do the same. If you have heard from him. Great. So he will be here this morning at some point. Thanks for the update.
Judge, I've got a hearing in front of Judge Carnesel. Can I step out for like 20 minutes? To do
Sure. No, go do that. Did you all get the orders?
Yes.
They-
They've been submitted to the.
Great. They are at the appropriate places. Okay. Thank you. And then finally, Ms. Didier, she may have been excused. I don't know. There's a Muhammad on, but that may not be Mr. Muhammad. Uh-oh, did I miss someone? Hold on one second. Ms. Didier, I have already signed this morning while we were waiting, I signed the pretrial diversion because they accepted that. So we're good on that? Trial diversion. All right. Did I not get to the very? Oh, 33. Yeah, Mr. Lowe, is he here? Oh, he can go. He is with another docket. You could take him to 7E. Was there anyone here who didn't hear their name called that they thought they had something today? No? Okay. Then Ms. Smith, I'm gonna have you go to the jury room. Lawyers can come talk to you. And Ms. Willingham, what do you you're waiting to see if there's whether Foster's a plea or not, or okay. All right. We will handle Mr. Compton's sentencing now.
Okay, I just need to talk to him for like 2 minutes.
Sure.
Good.
Okay.
So Compton is a
Go get comfortable.
murder. Mr. Compton, Kente, Kennard, Compton, is that who?
Your Honor, I have an appearance in front of Judge McBurney at 11, and then I need to run down to check on our preliminary hearing at 1 p.m. But I don't know like that.
Okay. If Ms. Nelson knows how to reach you, we can just let you know. Mr. Johnson can let us know when I may recognize when he comes on in, but when Mr. Jones gets here, we'll just want to let you know that he's here so that you can, if you can be diverted or whatever. And, I mean, if he gets here in 10 minutes, then you should feel free to go now as long as we have a good way of reaching you.
Absolutely, and I can come right back.
Okay.
Thank you.
Mhm. Yes, but Mr. King's not here yet. When I see, but that's another add-on and we have a revocation. Oh, that's Ms. Ford. Yeah, and she wasn't here yet, but yes, Mr. Moses has decided to take a plea.
It's a full calendar, y'all. My God. You're not late. Will just walked out for a minute because he said he had to go down the hall for something, girl. It just glazed over my head. But if you hit the back button for a second, Miss Jones is there, Kayla Brown's mom. However, Mr. Jones, her brother, I'm assuming, Mr. Ardonis. Gosh, why am I saying his name wrong? Jesus. Mr. What is his name? Adarin. Mr. Adarin hasn't arrived yet, and his lawyer is Nicole Mormon. It's like, sir, why are you not in court yet? So Trakila is there. Her brother is not. I don't know if her situation is contingent upon his, but baby, I sir, why are you not there? Court started at 9. It's 10:20.
Yeah.
I'm not messing with you, Cyber World. I'm
Come
not.
stand right here, Mr.
Cyber World. I am not messing with you.
Mr. Body,
He
you-
was on yesterday. Any of my McBurney watchers, he was there yesterday, right? We'll watch this, but if you want to go back to hear what all of the situation was, we'll have to go, because I started watching this yesterday and I was like, I'm gonna come back to it, and I never did, but I recognized him because his hair was like all in his face, just like it is right now. Girl, yeah, Cyber World is on some foolishness. We Oh God.
Ready?
We gonna leave sis with the problematic hairline situation. We gonna leave her alone. Okay. Sir is getting ready to take that plea.
All right, Ms. Allen, we're going to get on the record. This is position 1 on the trial
Mr.
calendar.
Abadi is coming.
It's case 23 SC 187611, State versus Compton. Mr. Compton is here in court with his lawyer, Ms. Wood. Mr. Abadi is here for the state. And on an earlier date, and good morning, Mr. Compton.
Good morning.
On an earlier date, Mr. Compton entered his plea in this case, and the state put on the record its recommendation, what it was committing to. Mr. Compton said he understood that and wanted to move forward with it. We didn't get to the sentencing piece because Mr. Yancey, who's the decedent in this case, his family didn't have adequate notice when we took the plea. And so I wanted to be sure that the state had an opportunity to have any members of Mr. Yancey's family to be present, or if they had impact statements that they wanted Mr. Abadi to share, they'd have an opportunity to do that. So, Mr. Abadi, why don't you start by stating again what the state's recommendation is in the case, and then I'll turn it over to you if there is any victim impact, anything.
Sure. The recommendation made by the state.
You may need to move the microphone towards you.
The recommendation by the state at the last hearing that we had was 20 years to serve 15 years in custody, with the remainder to be served, the balance to be served on probation, Your Honor.
And that was a reduction of the murder count to voluntary manslaughter.
That is correct.
Okay, and then the felony murder was vacated, aggravated assault would merge. And so was it 15 for the voluntary plus 5 for the firearm, and that's the 20 to do 15?
That's correct, Your Honor.
Okay, that was my recollection.
Members of Mr. Yancey's family are present. His mother, and I believe it's his grandmother, are present, or his aunt. I'm so sorry, I'm wrong. But she, and I will express for her, and then she may feel comfortable making a statement. I can wholeheartedly say that she does not, their family does not agree with the resolution, and I completely understand why. But looking at the totality of the circumstances and all the facts and circumstances through the investigation of Detective Sinling with the Atlanta Police Department, the state felt this was the best recommendation and outcome. So
balancing the risk of going to trial and not a favorable outcome for the Yancey family versus the certainty of a plea. And yes, it's a different sentence, but there's a different level of closure.
correct, and it allows Mr. Compton to take responsibility for his actions that night.
Okay. So I'm happy to hear from either or both of you. It sounds like Mr. Abate and people on his team have had some good conversations with the family where you've been very candid in an understandable way about your feelings about how this has played out. If there's more you want to share with me, I'm happy to hear that. You also may say, we've spoken our piece. But I want to make sure you have that opportunity. Okay, what I'd ask you to do is come on up to the prosecution table. If you could take a seat in the middle seat. Our court reporter is virtual, and so she needs to be able to see and hear you. Good morning.
Good morning.
So if you could let me know your name and your connection to Mr. Yancey.
Yes, my name is Latina Mitchell, Latina Mitchell. I am Beyonce's mother.
Thank you for being here.
Thank you. I wasn't prepared today to say anything, but sometimes you have to speak from your heart. Beyonce was a grandchild, a son, a nephew, and a cousin, and a friend. I don't know what happened that day or how everything went on, but what I do know is my son is okay. I'm not a big believer on, religion, but God has showed me that my son is okay. It was so hard just to deal with what I'm going through. The only person that could make me feel okay was my mother. And my mother died 5 months later. I don't know how to bear with this. I have breakdowns still. I can barely work. Nightmares. I'm trying to pull myself together and what my son would tell me to do. Sometimes I feel like I'm not even myself half of the time. When I heard the last court case with the sentencing, I heard
When you say the last court case, meaning the co-defendant?
yes, sir.
No, the sentence.
Not the sentencing, the plea that was given. I heard Mr. Compton say that his girlfriend was his everything. My son was my everything. I'm glad you get to see your everything every day. Through visitation, through writing letters, even when you get out. And I would hate for someone to sit up there and not have that everything. To see that pain and that heart. I'm just a mess every day. And I have the support of my family, but sometimes you're by yourself. I have to by myself. I don't have my son anymore. I don't have my mother anymore.
Was he your only child?
He was my only son. I have a 12-year-old daughter.
Okay.
And when you're going through mental breakdowns and you can't be there for that 12-year-old, and you don't see what she's going through, it's hard that I have to sit up there every day and be faced with this opportunity to sit up here and just be okay with this. But I'm glad that God has covered me, secured me mentally and physically. Me and my family are going through it. Just losing people back to back. Holidays are not the same. Birthdays are not the same. And I have to go to a cemetery to celebrate my son and my mother. And it's hard. I appreciate the courts for everything. I appreciate you, Mr. McBurney. I'm going to get through this. I just pray that God will be with you, Mr. Compton. I pray for his family and everything. Thank you.
You're welcome. You're very gracious with your words. And I want to share one thing with
it's
you, which is it
heartbreaking,
doesn't have to be
y'all.
okay. You said that, you're just trying to make this okay. What happened wasn't okay. It doesn't have to be okay. What you want to focus on is your healing and being there as best you can for that 12-year-old, because you are still a mom. You'll always be a mom to Mr. Yancey, but you're connected with him in a different way. In a much more tactile, present way, you're connected with your daughter. So the more you can try to heal through this, the better it will be for your daughter. And hopefully that's a motivator for you to keep moving forward. But I don't ever want you to think that for some reason this needs to be okay. No one is saying it's okay. This resolution is a way to bring closure to it in a way that can be sometimes less painful than if there's a trial and everyone's looking at pictures of what happened, and that can be even more disturbing. So I wish you the best as you continue to recover from this. You won't forget, but in a very healthy way. You already seem to be extending grace to Mr. Compton, which means you may have already gotten your arms around the anger, and so it's the grief that remains. But I appreciate you taking the time to be here and sharing the ongoing impact this has for you and for your family. I wish you the best. You're welcome. Anyone else? You don't have to say anything at all. If you do, you need to switch places so the court reporter can hear you. Well, okay. All right. Thank you, Ms. Mitchell. Anything else from the state?
No, Your Honor.
Okay. Thank you for that. Ms. Wood.
Thank you, Judge. Mr. Compton is 22 years old, Judge. He is from Atlanta. He does have family support. I'm not sure, as you know, when we took the plea, he had his significant other who was here all day. I did reach out to her, and I'm not sure if she was able to log on virtually, but he does have that support. He does have one young child with her. Your Honor, he's accepting responsibility. I know at some point in this journey, we had talked about the possibility of him wanting to go to trial and argue self-defense, because as you know, there was the codefendant and there were other people involved. I think that would have been quite tricky.
Given the number of shots fired, I think it would have been complicated.
Yes, Judge. And so we appreciate Mr. Abadi working with us on this case. He is accepting responsibility. He has been in custody 288 days. So we've asked for that credit. And then finally, Mr. Compton had asked me, part of our negotiations, I had asked, or he wanted me to ask that the 5-year probated sentence be suspended, sort of be more in line with what Mr.
Chalmers?
Yes.
Okay.
But that's all.
Okay. Got it. I appreciate that. Mr. Compton, you have the right to say something if you want to. You don't have to say anything at all. But in the same way that I need to hear from any of Mr. Yancey's family members if they want to be heard, I need to hear from you if there's something you want to add. You and I spoke during the plea part of this process, so we've already had some of that conversation. But if there's anything you want to add, this is your opportunity to do so.
You don't have to say anything.
No? Okay. Well, Mr. Compton, I do find, I probably said this before, but we're going to double cover it, that there's a factual basis for your plea, and that your plea was knowing and voluntary. Knowing means you've understood the things we talked about. Do you have any questions about any of the things we discussed today or last time we were together? You got to say it out loud.
No.
No. Okay. Voluntary means no one's forcing you to enter this plea. It doesn't mean that you're enthusiastic about it, but it means you've decided that this is the right way to move forward rather than going to trial, running the risk of a guilty verdict, which could result in a sentence of up to life without parole. Is it fair to say that your plea is voluntary?
You have to say yes. Or if it's, do you feel someone's forcing you to take it?
Do you feel like anyone's forcing you to enter this plea, Mr. Compton? I'm not asking if you're excited about it, but I need you to tell me that no one's twisting your arm or saying, I'm going to hurt your girlfriend if you don't plead guilty or something like that. Is anything like that happening? No? You just say it out loud.
No.
Okay. You made it through.
I would have been like, let me tell you something. Number one, here's a rubber band. I'm going to need for you to get your hair out your face. I don't care if that's why you know, like, get your hair out your face. And there are things that you don't have to respond to, but there are some things that you do. Like the rocking is just, come on, sir.
Ms. Wood, any objection to having someone in my office sign for you and sign for Mr. Compton on the indictment?
No, Your Honor, thank you.
Mr. Abadi, can someone sign for you? We'll do that. So Mr. Compton, count 1 of the indictment, murder, the state has reduced to voluntary manslaughter. I'm sentencing you to 15 years to serve on that. You will receive credit for every day you've been in custody in connection with these charges. Count 2, felony murder is vacated.
Sir, are you nodding? Like, or did they give you some sort of fruity punch? Did you get some of the drinks in the jail? Like, what is this? He wasn't doing it before, but I don't know, maybe something's kicking in. But they're gonna take care of that hair when he gets to prison. They're gonna shave it all off. He's gonna get a baldy. I don't know what you call it. They're gonna shave him down clean, I'm sure.
By operation of law. Count 3 merges into count 1, no sentence to count 3. Count 4 is a 5-year sentence that must run consecutive to all other counts, so it'll run consecutive to count 1. It will be 5 years, and I am going to probate it. I think your situation is a little different from Mr. Chalmers, and I think giving you some connection with supervision upon your release makes sense. The only condition of probation that I'm going to impose is that if you don't do it while you're in custody, is that you get your GED. You told me you got close to graduating, this close. And I want you to finish that. So you'll need to get your GED while you're on probation if you don't get it while you are in custody. Mr. Abadi, anything else from the state? All right, Ms. Wood, anything on behalf of Mr. Compton?
No, Judge, thank you.
That's it. Thank you.
And oh, nasty.
And thank you again, Ms.
Okay.
Mitchell, for taking the time to be here.
Ooh, baby.
All right. We don't have a prosecutor in here, so I don't know what else we're going to do.
Yeah.
Oh, Ms. Smith, Ms. Smith.
Oh, Ms. Smith went outside?
Ms. Smith.
Oh,
Ms. Smith.
you're not using your outdoor voice. Hey, Ms. Smith. Psst, Ms. Smith. I didn't mean to interrupt. You can go back to that conversation. I just wanted you to lay out if there's something you're ready, a plea you're ready to do. We could do Ms. Chambers. I think we have a couple other folks who maybe were ready. If they don't involve Ms. Wood, I think Ms. Wood is diving into talking with people there. If we can find Ms. Cabrera.
Ms. Wood, yeah, Ms. Cabrera would do, Ms. Chambers.
Okay.
All the rest of the pleas are Ms. Wood.
Ms. Wood. So why don't we try to do Ms. Chambers's plea, and then maybe Ms. Wood will be ready on one, and we'll pivot to that. Did you need to finish the conversation you were having?
It was with her, so I would go here.
Okay.
It wasn't about Chambers, no.
Okay.
Yeah.
Oh, nothing for,
Yes, Mr. Dumbuya, let me find him in here. So I'm keeping up. Position 19.
we agree to the continuance.
Well, you all can agree to continuance. It takes 3 on that one.
So in this case, Judge, I had opportunities, I got some additional discoveries from Attorney Lane, and I followed up on that discovery. We just had a conversation, we're still kind of far apart regarding what the resolution to this case would be. So I told them that the likely next step would be trial. I did speak with the victim in this case, who told me that he is a truck driver, 18-wheeler, and he will be in Chicago the week of June 22nd, so he would not be available for trial.
Okay.
So we're asking for the continuance. So at this moment, because it's not resolved, we ask for the on the trial calendar.
And there's no objection from the defense to the continuance. Okay. I think we're past final plea here. So if there is a plea, non-negotiated or not, that it would something that would be binding on the defendant. But it sounds like the two sides are far enough apart that it's not going to be a non-negotiated plea today. Is that a fair statement?
Yeah.
Okay. And this isn't one where it makes sense that, well, maybe we'll reach it next week because your victim is out of pocket.
That's correct.
Okay. All right. Then that's what we'll do. Mr. Dumbuya, you will get notice in the mail, but more importantly, Mr. Lane will be in touch with you when this case is next on a trial calendar. And that's where it's staying. It's just going to keep being on a trial calendar. So I'll let Judge Ellerby know that if next trial calendar, the answer is we don't agree, then we need to try the case. Because you don't need to agree. It may be that you're far apart and a jury will figure that one out. This will be the one continuance absent the unavailability of a witness. But assuming all the pieces are in place for the next trial calendar, it's either resolved or a jury sorts it out. Okay. Mr. Dumbuya, do you have any questions for me? All right. Ms. Smith, anything else?
Nothing further, thank you.
Mr. Lane? All right, you all are excused.
Okay, next case.
Person, but she represented and Mr. Say that.
Greer?
Mr. Bates is a plea negotiated. Mr.
Excellent.
Chambers is a plea negotiated. Mr. Greer, we will come back to maybe later than today.
Okay.
So he can be released. He has a homework assignment that he's going to do, and I was off the state.
Does his homework assignment, it's something that could lead to a resolution? You don't know. It's in that direction. Okay.
Or maybe changes what the state's current recommendation.
Right. That's what I mean, is that it's something that isn't, that you ultimately could be handed to Ms. Smith.
Yes.
Okay.
Yes.
All right. Mr. Greer, do you have any questions about what's going on? Okay. Do you know what your homework assignment is? All right. Work on that and stay in touch with Ms. Cabrera. Okay. All right. You're good to go.
You're welcome.
So we're going to do Ms. Chambers now? That the preferred? All right. So Ms. Allen, this is position 34 on the trial calendar. And let's find Ms. Chambers.
Sorry, we're here.
Mr. Washington, U.S.
Yes, you're going to be handling that bond hearing? Yeah, we'll let you know. We've got Ms. Gibson's phone number, so we'll let you know when Deputy Gordon says the right Mr. Washington is here. All right. And I saw Mr. King.
He was in the hallway.
Okay. All right.
He's going to Ingram, Judge.
He is going to Ingram also?
Yes, he's coming right back.
All right. Ms. Chambers, can you hear us?
Yes, sir, I can. Good morning.
Great. Good morning. It sounds like your internet is back on.
Yes.
All right. Well, let's tackle this while it's going.
Hurry through it while we can.
Yep. So we're going to get on the record. This is position 34. It's 25 SC 006136. Ms. Chambers is one of 4 defendants charged in this armed robbery case. And we've taken one plea, and then one of the other cases has been resolved. Quick timeout. Mr. King, good morning. Mr. Moses is here. Is he up?
Yes.
Do you need to talk with him?
I would say no more than a minute, Judge.
Okay. Well, we're in the middle of a plea. I just wanted to make sure if you needed access to him, you got access.
Yeah, I want to talk to him real quick just to make sure we're on the same page, but I think we're good.
Okay, great. Back to Ms. Chambers. Ms. Chambers is appearing virtually. Ms. Cabrera, her lawyer, is here in court, and Ms. Smith is here in court for the state. Ms. Chambers, in a moment, Ms. Smith is going to put you under oath and ask you a bunch of questions about your case and your rights. You need to answer her questions truthfully and completely. You also need to let me know if at some point you cannot hear what's going on because there's a bad connection or whatever's being said is confusing to you. Will you do that?
Yes, sir.
Good. I have 2 questions for you before Ms. Smith starts. Ms. Chambers, are you willing to waive your right to be present here in court? You have a right to be here in court, but you can waive it and appear virtually. Are you waiving that right?
Yes, sir.
Okay. You also have a right to have Ms. Cabrera right next to you, so you guys could have a little huddle and talk. She is here in court. Are you waiving your right to have your lawyer by your side for this plea?
Physically, yes.
Okay. If you need to speak with her, let me know. She can step outside and call you up on your cell phone and you guys can have a private conversation. Okay?
Yes, sir.
Excellent. Let's get started, Ms. Smith.
Thank you, Judge. Before starting, I just wanted to inform the court that counts 1, 2, and 5. So that's the armed robbery, ag assault, and kidnapping charge will be null pros in this case. And the state will be moving forward with count 8, which is financial transaction card theft.
Got it.
What happened to the kidnapping and the armed robbery? Like, how do you? We'll talk about that at a later time. We'll have to reserve that conversation. But armed robbery, kidnapping, and girl, my brain went blank. Bless. Okay, that's all I'm gonna say. Bless, bless.
Ms. Chambers, please raise your right hand.
And she gets to phone it in on Zoom, baby. We're going to talk about it at a later date. We're not going to talk shit while we're trying to still be on the live because we don't want it to turn off. So let's just, we'll talk
Make
about
sure
it
you
tomorrow.
speak up loud enough.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Ashley Chambers.
What was that first part? I'm sorry.
Ashley Chambers.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
31 and I have my associate's degree.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
So
Ms. Chambers, do you remember being arrested on these charges?
Yes. Can you hear me? Yes.
Okay.
we hear you better now.
The state is
Sorry.
unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No warrants.
Okay. Ms. Chambers, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 3 years probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge?
Yes.
I can't hear you.
Yes.
Okay. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
I'll repeat
You
that
said
part.
yes.
Oh, she said yes?
Mhm.
Okay. Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Are you a United States citizen?
I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Ms. Cabrera, is this under first offender?
Yes, it is.
Ms. Chambers, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No,
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
no,
Has your lawyer explained what the First Offender Act is to you?
yes,
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for the charge in this indictment?
yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
yes,
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Ms. Chambers, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 006136, how do you plead to count 8 financial transaction card theft?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes,
Do you understand that you do not have a right to directly appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
yes,
Do you understand that that process must be completed within 30 days from today?
yes,
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
yes,
Okay. Thank you, Ms. Chambers. Judge, if this case were to proceed to trial, the facts would show that on August 6, 2025, officers with the Roswell Police Department responded to a robbery
Roswell.
call near the Roswell North Elementary School. That's at 10525 Woodstock Road. That's also in Fulton County. When the officers got there, they spoke with Miss Johnny Pierre, who's the victim in this case, who stated to the officers that she was meeting an acquaintance identified as Miss Ashley Chambers. They met a week prior at a store where they exchanged information. They got to know each other, and then they further communicated about meeting up later that week to open a bank account. In this case, they were opening bank accounts all together so they could put checks in the account and get the money out. So on this day, August 6, 2025, they all agreed to meet up. When Miss Pierre got to the meetup location, she saw Miss Chambers, the defendant in this case, and 3 others that was in the car with Miss Chambers. Miss Chambers was not driving, she was the passenger. So in this case, Miss Pierre got in the car with Miss Chambers and the 3 other people, and how they were set up in the car is you had Mr. Cotton, who's already pled in this case as the driver, Miss Chambers as the passenger. Sitting behind Mr. Cotton was Mr. Thomas. In the middle was Miss Junicent, and behind Miss Chambers was the victim in this case, Miss Pierre. In this case, Mr. Cotton took the group to a couple of banks where Miss Pierre was supposed to create these bank accounts in an effort to get money for the group. So after they went to a couple of banks and nothing came from it, the group grew irritated of Miss Pierre. And at that time, Mr. Cotton and Mr. Thomas, at that time, Mr. Thomas is reported in the report that he pulled out a gun to force Miss Pierre to give him all of the money that she had. Kind of simultaneously, Mr. Cotton, the person that's driving, hits Miss Pierre in the face. After that, he takes her bag where she has her credit cards.
Mr. Cotton takes the bag.
Mr. Cotton takes Miss Pierre's bag and gives it to Mr. Thomas to go through and take her credit cards out. After that, Miss Pierre was let out of the car. Mr. Cotton told her to get out. She got out. They still had her cards. They still had her personal information like her ID and things like that. So after the group let Miss Pierre out, they traveled to a nearby convenience store. When they went to that convenience store, the entire group got out of the car. They then went inside of the store where they purchased boiled peanuts, drinks, different items like that. And half of that purchase was paid for with cash, and the other half, as it's reported, was paid with Miss Pierre's, the victim in this case, credit card or her time card. Because of that, at the time, the person who was in possession of those cards was Miss Chambers. She had her ID and also her time card. At that time, the Roswell police officers pulled up to the gas station because it was a bolo out for the car at that time. Officers were able to detain all of the 4 people who was inside of the car, including Miss Chambers, but she was in a bathroom prior to coming out and being detained. Officers went inside of that bathroom where they found Miss Pierre's ID and her time card that was used in the transaction. Because of that, Your Honor, in the facts and circumstances of the case, nor processing those other 3 charges, but keeping the financial transaction card theft based on these facts is the reason why we're going forward with count 8. I have talked to the victim multiple times, and she told me that Miss Chambers, she does not believe was involved in the actual armed robbery because she did not contribute to it or yell at her or anything else. Miss Chambers just kept quiet. However, she was comfortable with us moving forward on count 8 because her card was used and was in the possession of Miss Chambers at that time. Those are the facts and circumstances of the case. Regarding the negotiated plea between the state and defense, we've agreed to, for count 8, 3 years probation. Regarding those special conditions of probation, we're asking for the defendant to complete an anti-theft course, to have no contact with the victim in this case, to also have no contact with the co-defendants, to complete 40 hours of community service, and also to testify truthfully at trial. And that is all from the state, Your Honor.
Got it. Okay. And is there restitution for the boiled peanuts and sodas, or?
Not at this time.
Not at this time. Okay. All right. Ms. Harvey from pretrial, good morning.
Good morning, Your Honor.
Can you share whatever information you have about criminal history for Ms. Chambers?
Yes, Your Honor. 5 cycles out of Georgia and 1 cycle out of the state of South Carolina. Does not appear to have any prior felony convictions. The last arrest was February 11th, 2024 out of Clayton County for driving on a suspended or revoked license. There was no disposition listed for this case. There are 2 misdemeanor shoplifting convictions, one from 2011 out of South Carolina and one from 2014 out of Clayton County, and nothing further, Your Honor.
Got it. Thank you so much. Ms. Cabrera.
Yes, Judge. Ms. Chambers is 31 years old. I am definitely going to be asking that Your Honor accept the plea as negotiated. She does her best to get here back and forth to court. Today was not the best day, but she usually tries to Uber or tries to do something to make sure that she's here. She's been incredibly cooperative. She had an opportunity to speak to the state to bring them up to speed on what her involvement was in any of this and what may have happened, which I think was helpful. I would be asking that her plea be allowed to be entered under first offender, and that if I provide an order to the court, that it be done under seal. There are things that she definitely still wants to do, and she does not want this following her at all.
Okay. All right. Ms. Chambers, anything you want to add?
Morning.
All I can say was this. Was, I can't even think of the word. I do, apologize for any involvement. I just felt like I was in the wrong place at the wrong time, honestly. So,
Who did you know who was in the car? You obviously knew Ms. Pierre in the sense you guys had met, but did you know Mr. Cotton or Mr. Thomas?
I did know Mr. Cotton. He's a friend, but obviously I'm not that best of a friend or good of a friend or a close of a friend to not get the information that you were about to do something dumb. So I don't even really blame anybody.
Okay. Yes. Got it. Is your driver's license situation fixed, or what is happening with that?
Yes, sir. Yes. My driver's license, I had to take a driver's class and everything for that situation. So yes.
All right. Are you working these days?
I am trying to. I am not gonna lie. This case has put a bundle on my career right now. With this popping up on my background, I'm an X-ray tech, so I cannot get in my field with this. So currently, I am working, but I'm not in my field. I am.
And what did you say your field was? I didn't hear you.
I am an X-ray tech.
Say it one more time.
I am a radiologist. I take X-rays.
Oh, radiologist. Got it.
Yes, sir.
Okay, right. No, you can't be doing medical stuff with this open arm
Yes,
robbery
sir.
charge. Okay.
Yes, sir. Yes.
You are not a radiologist. Radiologists are medical doctors. You are a radiology technician. But I heard her say X-ray tech, but he couldn't hear her 2 times. But there's a difference.
Ms. Chambers, I know you and Ms. Cabrera talked about first offender, but I need to talk to you about it as well. You qualify for it. It is essentially a good opportunity for you. It means this is not a conviction. It means that even though you'll be on probation.
Well, they said she had 5 cycles, so it sounds like you've been arrested 5 times, but now you're at the big show. At the end of the day, 5 cycles, now you are taking a conviction, a guilty plea. You were in the shits. You socialize with a circle of people who did not think twice about kidnapping someone, stealing her car at gunpoint, threatening her physically, taking her money, trying to run her to the bank, all of the things. Like, ma'am.
You're not a felon. You don't need to check that box. And Ms. Cabrera's going to.
Right. She said she was a radiologist, right? We know what a radiologist is, right? So she said X-ray technician 2 times. He couldn't hear her. She said, I'm a radiologist. And that's why I was saying she's a radiology technician. And there is a difference between the technician and technologist. Yes. And our sis here has been one for 28 years. That's amazing.
Be getting me some paperwork that ought to seal up your record from the eyes of
I don't think she deserves to have it sealed, if you ask me.
Be employers, so that should help.
Yeah,
there is a small risk that you need to tell me you understand and that you are willing to bear. And that is that while you are on first offender probation, if you are arrested for something new, not only do you have new charges, but you could come back here and have your first offender status revoked because you pled guilty. I could go ahead and resentence you up to the maximum in this case. So it can end up in a bad way if you are not done with capers like the Ms. Pierre, Mr.
Yeah, don't fuck around with the fuck around. That's what he's saying.
Cotton caper. Do you feel like you understand how first offender works?
Yes, sir. Okay.
You still there?
Yes, sir. Can you hear me?
Yes. Were you able to hear me?
I heard the last thing you said was about revocation, and you would take it away if I got new charges.
Right. So you understand there's a risk to being a first offender. You understand that?
Yes, sir.
Okay. Do you want to be sentenced as a first offender?
Yes, sir.
Okay. All right. Well, Ms. Chambers, I find there's a factual basis for your plea and that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to plead. Do you agree with that?
Yes, sir.
I will sentence you as to count 8 because the state is dismissing the other counts that were brought against you to 3 years probation. Special condition number 1 is that you will testify truthfully should Mr. Thomas's case go to trial. Special condition number 2, you will complete 40 hours of community service. Number 3, you'll complete an anti-theft course and probation can help you find one of those. And finally, no contact with Ms. Pierre while you are on probation, and also no contact with any of your co-defendants. So insofar as you and Mr. Cotton were friends, you need to stay apart as long as you are on probation. Any questions about that?
No problem.
What county do you live in?
I live in Clayton County.
Okay. Do you want to get a phone number so you can give her a call?
But she has the phone number and the mailing address.
Okay. In just a moment, Ms. Chambers, Ms. Simpson from probation is going to give you a reporting date. You will report in Clayton County. You are supervised in the county where you live. So she'll give you that information, and we will go from there. Anything else, Ms. Cabrera?
Nothing for me, Your Honor.
Any questions, Ms. Chambers?
No, sir.
Okay. Ms. Simpson?
Good morning, Ms. Chambers.
Good morning.
So you're going to report to the Clayton Probation Office. Do you have something to write down?
Okay, we're gonna speed past because it sounds like she's getting ready to give some phone number information. So. Okay. Okay.
I have one other plea if Your Honor is interested.
I'm always interested in your pleas, but I did. But I need to
I feel like they're gonna end up breaking for lunch before we see Tanya Jones and Mr. Ardonis, or I don't know why. Is it Ardonis? Girl, I can never say his name. Adarin.
an update to Mr. Johnson. Mr. Jones sent an email. He is still in Walton County. The judge there just took the bench, so he will be here. He is forecasting after lunch at the earliest. So you should feel free. You're welcome to stay right here, but if you want to go find lunch and be back by 1, Mr. Jones should be
Thanks.
here by then. Okay.
Okay. So,
that is my update.
who knew that this was gonna? I mean, we're so spoiled that sometimes we get, girl. It's like first case out. It's position number 1 or 2 or 3, girl, and then Mr. Jones better get his behind to court, or else I wonder what's gonna happen.
Did you end up talking with Miss Tembeka? I don't see her. She's coming back. Okay, I just thought since we were on this case, we would talk about Mr. Thomas, but we'll come back to it. You have Mr. Chamber? No, Miss Chambers we just did. What's your other case?
So the next one I'm gonna have is Mr. Bates.
Mr. Bates, are you able to do that?
I am, but can I have a second to call the victim? I didn't
Of course. Ms. Rios, you ready to go on anything?
I hope we ready. I said, no, we were discuss it. Ready. John Riddles.
Is ready? Is that a Miss Smith case?
Yes.
Okay. We will do it right after. We're going to knock out Ms. Cabrera's other plea, and then we'll do Jerron Reynolds.
Where did Will say he was going? Will said he was going somewhere.
Yes. My other courts gave me virtual ones.
Will said
Look at that. It's our turn to get you, and they have to get you virtually.
I got 2 virtual ones. One of them has clients in deals.
I'm gonna run it back in my phone and see. Will said he was going somewhere. Okay. They're getting ready to do another plea deal, guys. Okay. Good morning. Good morning, everybody. Say hi to a friend in the chat. We're just, and then they're gonna go to lunch. He's already telling people to start to come back. So they're gonna probably do this plea deal. And then I would not be surprised if McBurney shuts it down. Or he'll put that gone to lunch sign up, which is always hilarious. Hey, how are you? Is it Tracy Mason? Hey, boo. Okay. If they actually break it down and go to lunch, we'll shut it down and come back at 1:00. Either way, we're going to shut it down and come back at 1 because nothing is happening right away. Lunch. I'm still eating breakfast. Okay. I haven't even ate mine. I told you guys earlier, we did a little member live real quick. And I was like, I'm going to go get some eggs. Never happened. Farah just woke up and she's making me some hard-boiled eggs now. Good morning, Salita. Good morning. Good morning, everybody. Okay, let's get through this. So we can have a little bit of time. I need to run something to the on a bougie gang legal mail. I need to run something to the post office, so I'm going to take some time in between on the break. I hope if he said that the judge, so it sounds like Mr. Jones is in the shits somewhere else. Did they say Walden County? Maybe we need to look that up. Is Walden County a thing in Georgia? Is that a place?
What you think?
Let's
Well,
Let's go to Pete's Court.
A point of privilege and just say how proud that I am of Ms. Cabrera when we were young lawyers and she was just what were you, case manager? And look at her, she's like blossom and she's a big time lawyer.
I still have one of her business cards because I took over Judge LaGrua's chambers.
Yeah.
And so there's a Euphemia Cabrera, I may have had a different last name, litigation manager card. I love it. It's a collector's item.
I mean, I feel like we had kind of like planted seeds and now she has blossomed. So I don't know if we should be more proud of us or her because she has reached this point. I just wanted to say that. Is that okay?
Well, it doesn't matter. You said it, so hopefully it's okay.
I think.
I'm seeing his back with this. So
Yeah, he been looking for you all morning. I thought it was in the jury room.
Oh, is it Walton County?
she's working.
And let's see. Jones.
Ms. Jones, what did you hear from Mr. Campbell?
Just that he had a couple of hearings.
Oh, okay. It's nothing new. It's that he went sort of like Attorney Jones. Same thing. Okay. Do you want more time and we do a different plea or you're good?
I didn't get her, but she knows about I just didn't know if she wanted to speak or not.
Do you guys know there's a restroom in the jury room? Yep. Go through there and then look to your right is the jury room. So you're good going forward. All right. And where's Mr. Bates? Come on up, Mr. Bates, please. All right. Let's get on the record, please. This is position 14 on our trial calendar, State versus Jason Bates, 25 SC 003518. Mr. Bates is here, so we'll have better sound with his lawyer, Ms. Cabrera. Ms. Smith is here for the state. And Mr. Bates, my understanding is you're prepared to enter a plea in your case now.
Yes, sir.
Okay. Ms. Smith will put you under oath, ask you a bunch of questions. You've heard what they are because we just did this with another client of Ms. Cabrera, so this will be fairly similar. Please answer the questions to the best of your ability, and please let me know if you have any questions of your own, okay?
Sure.
All right, Ms. Smith?
Mr. Bates, please raise your right hand.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can lower your hand. Please state your true, correct, and legal name for the court.
Jason Cornelia Bates.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Ma'am, I might not be feeling up the part, but I'm still all right.
Meaning you're not feeling well?
Yes, sir.
Okay, but you feel like you can go forward with this process?
Yes, sir.
All right, if you need to take a seat at any point, let us know.
Yes, sir.
How old are you and how far have you gone in school?
On to the 9th grade. I'm 43.
You're how old?
43.
Are you able to read, write, and understand the English language?
Not as well like that.
If you need anything explained, let me know.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Good.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So it.
Mr. Bates, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No warrants.
No warrants.
Okay. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
I didn't, you go back over that again.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Wow.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Bates, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 003518, how do you plead to count 1, aggravated assault, count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies, and count 3, receipt, possession, or transport of a firearm by a convicted felon?
Guilty.
You say,
Yes, ma'am.
okay. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right. Thank you, Mr. Bates.
Your Honor, if this case were to proceed to trial, the facts would show, my apologies, that on November 2nd, 2024, officers of the Atlanta Police Department was dispatched to 205 Harwell Place, Northwest Atlanta, Georgia, 30318. That's also in Fulton County. They got a report about a person being shot. When they got to the incident location, they went to an apartment complex that was owned by the victim or rented by the victim in this case, Ms. Cardwell. When they got there, they noticed shell casings in the parking lot and the bullet hole in the upstairs apartment unit, unit B, that was being rented by the victim in this case. The EMS forced entry into the apartment where they found upstairs Ms. Joyce Cardwell. She was lying between her bedroom and the hallway. She had a gunshot wound to her stomach. She stated to the officers that there was a fight going on outside. So this is an apartment complex we're talking about. There's a fight going on outside. She looks out the window, and while she looks out the window, she hears a shot. And before she knows it, she's the one that has this gunshot wound to her stomach. At this time, she was alert, she was present, and she was taken to Grady Hospital by EMS. After she was taken to the hospital, the officers then did an investigation where they found out that two of the people that were fighting in that parking lot was the defendant, Jason Bates, and also Ricky Hightower. They were arguing about, I don't know what it was about, but at that time, Mr. Bates took out a gun, tried to fire at Mr. Hightower. However, it missed Mr. Hightower and shot Ms. Cardwell, it went through her window and she was shot. The state got a chance to speak with Mr. Ricky Hightower, who was incarcerated at Fulton County in this case, where he told us and confirmed that it was Mr. Bates that he was arguing with that night, that it was Mr. Bates that took a shot at him, missed it, and it went through Mrs. Cardwell's window where she was shot. In this case, I spoke with the victim, Ms. Cardwell, who said that at this point, she just kind of wants the case to wrap up because it's been a very long time.
I don't blame her.
She is still sometimes dealing with back pain, fatigue, and things like that. She was.
Let me tell you, you hang out in them windows. She was looking out the window, rightfully so. That's her prerogative, and caught a stray.
She told me that she's kind of older, so a lot of these things come with age, but also it's worse than because she did get shot. She said that she does not know Mr. Bates. She moved out of the apartment complex after this, and she has not returned since. I did talk to her about the probated offer in this case. It was encouraged by her because once again, she wanted the case to be resolved. She does not believe that Mr. Bates intentionally tried to shoot her because they don't know each other, and she knew that he was trying to shoot someone else. However, she wants him to take accountability for what happened. So with the facts and circumstances of the case, and also with the talking to the victim about what a resolution would look like in this case, the state is offering 10 years of probation for the charges we have in this case. Regarding the special conditions of probation, the state is asking for the defendant to stay away from the incident location. It's my understanding that he had maybe a godmom or grandma who lived in that apartment complex. I'm not sure if she still lives there. However, we would ask for the defendant to stay away from the incident location. We will also ask for the defendant to have no contact with the victim. Again, she does not believe that he knows who she is. However, through discovery and learning her name and possibly someone else knowing her from the complex, the victim in this case will ask for no contact. We're also asking for the defendant to complete an anger management course and 40 hours of community service. And that is all from the state, Your Honor.
That's plenty.
All right. So Miss
Jesus.
Cardwell, she's okay with not more jail time for Mr. Bates.
That's correct.
And Mr. Hightower, I know he's not listed as a victim, but that's who Mr. Bates was trying to shoot.
Yes.
He's okay with this.
Well,
you may not have asked him
when I went to speak with him, he just kind of told us about what happened that day.
what the deal was.
What he felt about jail time for Mr. Bates.
Okay.
And to add on to that, Your Honor, we had previous conversations where custodial time was the offer that was given in this case. Back in February, the case was on the trial calendar where we
continue it because the detective wasn't available.
Correct. But during that time, I have been speaking with Ms. Cardwell, and her biggest concern is to have to come to court to testify, to go through the trial. So she said this resolution is something she's okay with because she wants the case to wrap up.
And she would just hope that Mr. Bates would take accountability and not get into any more trouble over the next 10 years.
Okay, got it. And Ms. Harvey from pretrial, tell me about Mr. Bates.
Yes, Your Honor, 33 cycles, convictions from 2022 for aggravated assault, simple battery, family violence, possession of a Schedule I controlled substance, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. 2020, possession of marijuana with intent to distribute. Also, 2020, sale of cocaine and sale of a Schedule II controlled substance.
Come on now.
2020, possession of a firearm by a convicted felon, possession of a firearm during the commission of a felony, possession of cocaine with intent to distribute, possession of MDMA, possession of a Schedule I or II controlled substance. 2000.
That's what 44 looks like when you're doing MDMA and all kinds of other controlled substances, and you got 33 cycles. That is 43 at 33 cycles. Yeah.
12, possession of cocaine with intent to distribute, and 2001,
Cocaine.
aggravated assault. And nothing further to add, Your Honor.
That's enough.
That was plenty. Thank you.
You're welcome.
Ms. Cabrera.
Yes, Judge.
McBurney!
Trying to accept the plea as negotiated. He has mental health issues.
44
he has some
hard.
physical issues, ulcers and other stomach issues. He is in the process of starting.
You got stomach issues because you probably don't eat. You probably busy with that narcotica. You busy with that narcotica. If you would eat some protein and some carbohydrates and something from the earth outside of that narcotica, you might be all right.
Therapy at a
Of course your
program on
stomach is
Edgewood,
messed up.
where he will receive counseling. With his stomach issues, he's often admitted into the hospital. So whenever he goes into the hospital for the ulcers or anything, he's admitted.
On that narcotica.
So that was one of my concerns as it relates to community service. I'm just I don't want to set him up to fail the community service. But that was my concern, and I did speak with the state about that. So she actually did cut the community service hours by what she initially had requested. There is
go stock boxes at the Second Harvest Food Bank. Go to Goodwill and volunteer. Go to I don't know what they call it in Atlanta, but I'm sure they have like Crisis, the place where you go get clothes, food, emergency funding. Those places are full of people who need to volunteer hours and need people to volunteer hours and time. Go. And Goodwill services.
There are bipolar issues and things like that he's managing. He is on disability. While he was in custody, he lost a disability. So he is going back through the process of getting back onto the disability that he had. He has children, he has grandchildren. He's supported here today. So I'm asking that Your Honor accept this plea as negotiated. I do not know that he is eligible for any sort of behavior incentive date. If he were, then I would ask for that. But that's what I'm asking for, Your Honor.
All right. Mr. Bates, how many kids do you have?
I got four. I got four children. I got 2 girls and 2 boys, and I got 4 grandkids.
It's a good collection. Are they local?
Yes, sir.
Tell me, are you taking medication now for any mental health diagnosis?
Well, I'm starting my I'm starting it up.
So that would be no.
Have you used to take the medication?
Yes, sir.
And then you stopped?
Yeah, I got started out back over with my disability and all that.
Okay, so without the disability, you cannot afford the medication?
Yes, sir.
What were you taking before?
They had me taking Seracryl, and they had me taking some Hound Dog.
Well, yeah, the names don't matter to me so much as for what were you taking them? What did the doctor say you were taking it for?
Bipolar and schizophrenia.
Okay, but right now you're not taking that medicine.
No, sir.
Do you feel like you're understanding what we're doing?
Yes, sir.
When's the last time you worked?
Last time I worked, it's been a minute.
Okay. And where do you go on Edgewood for therapy? What's the name of the place?
It's right downtown. Yeah, I don't know. I can't recall it.
But you know how to get there?
I know how to get there.
Okay. And where are you staying these days?
Well, I'm staying with my fiance, her friend.
Oh, but
do you see how some people can always find a boo? I'm sorry, but for the average woman, you got all this trouble. There's no man that even wants you. Even a bum doesn't want you. But do you see how a man like this can have a fiance? What kind of husband? Let me not get started. This is not husband quality. This is not husband material. There is no fucking way. Okay? No fucking way. But it's so sad this a man who is in this type of situation about himself can actually form his lips to say that he has a fiance. And there's some dummy out here that's cool with it. But let it be you or me, baby. These men wouldn't even spit on you. Okay. 33 cycles, 4 kids, 4 grandkids, no job, not taking your medicine, on for some criminal charges, shooting indiscriminately. You got a victim over here who's probably so afraid to deal with coming downtown to testify. She's ready to just let him be so she doesn't have to deal with it anymore. This is absolutely ridiculous. Okay. This is very sad. I'm just really also in shock that this guy has a fiance. This is crazy. As a woman, you got to be on point. Hair done, nails done, job on point, clothing on point, looking fresh, have your children together, all of the things. This guy can be a complete bum and has the nerve to talk about he got a fiance. I'm in shock. I'm still in shock at the woman that calls this man fiance. Cause sis, I hope you're watching, cause baby, you stupid.
What part of the city is that?
Fulton County.
It's in Fulton County. Is it in Atlanta or?
In Atlanta.
Okay. What neighborhood is it in?
It's on the west side. It's on west side.
Okay. How long have you been
He
in?
might be a complete different person once he steps out of this court. 33 cycles. You don't think he knows how to behave in the courtroom and talk to the judge all very nicely and, respectfully. 33 cycles and this man is still out and about getting to make decisions. He knows exactly how to handle this business.
Engaged.
I've been now at least about 4 months now.
It's a new relationship.
Yeah, we need fiance to
How'd
come
you
to the
guys
front
meet?
of the room.
Well, my fiance, she been knowing her friend for a little minute. So she she rent us a room now.
Okay. How do you know Mr. Hightower?
I don't really know. I know him because of my girl.
Okay. And what were you guys arguing about?
We want to argue with him and another dude named Brian were arguing.
And how'd you get involved?
How'd you get mixed up in that?
I don't know how I get mixed up in that, sir. I guess because, he cut on down the line, I was trying to defuse the wedge. I was trying to defuse it, but it wasn't me. It was the other guy who he thought it was me, but I was trying to defuse the fight what they were going at it with.
Okay. Do you have any questions about anything we discussed?
No, sir.
So you
All right.
were
Well, Mr. Bates, I find
you were trying to diffuse the argument with a gun, and then you ended up shooting the lady in the window, not minding her business. You ended up shooting her. You were all up in other people's business with a gun, ready to kill somebody, because that's what you do with a gun. You end up shooting some old lady who has nothing to do with anything. And you got into this because of your girl? Girl, this is a whole mess.
the factual basis for your plea. This is a real tragic situation. We're lucky Ms. Caldwell wasn't more seriously injured.
Absolutely.
I know you weren't aiming at her, but when you pull a trigger, you don't control where that bullet goes. Hitting Mr. Hightower wouldn't have been a good thing either, but Ms. Caldwell didn't have anything to do with anything. She's minding her own business and you shot her in the stomach.
I don't care if she's a prize or not. The fact that a man of this, in this particular circumstance, can actually formulate his lips to say he has a fiance, she could be just as much of a bad news situation as he is. I'm not assuming that she's a prize at all. The fact that this man can say he's got a fiance is absolutely crazy work to me. Clearly she's no prize. There's no woman that would a prize female that would deal with a guy like this. It's just the utter gall of this guy in this situation to formulate his lips talking about he got a fiance. This guy is in no position to be a husband, and clearly the woman can't be a prize. Like, that should almost go without saying. So I am not making, you're making an assumption that I'm making an assumption she's a prize. He has a fiance. She could be living in the gutter right with him. I wasn't talking about her quality. I'm talking about her sanity. She's a fool. That's all I'm saying.
Well, I find there's a factual basis and that your plea is knowing and voluntary, meaning you've understood what we
It
talked.
just amazes me how men can find sex and women and be at the bottom of the fucking barrel. Most women don't have that luxury. Clearly his does. It wouldn't surprise me though if his woman is not as bad as him, because there are women who like projects. They like a fix-up project. They like a little DIY dude, and he might have himself a lady who feels like she's on a DIY mission. I don't know. I don't know what they got going on. I'm just in shock that he's got a damn fiance.
About, and that no one's forcing you to enter this plea. Do you agree with that?
Yes, sir.
Okay. Ms. Cabrera, do you authorize someone in my office to sign the indictment on your behalf and Mr. Bates's behalf?
I do, Your Honor.
Ms. Smith, can someone sign for you?
You're good.
All right. So Mr. Mr. Bates, here's how I'm going to handle this. Count one, I am sentencing you to 5 years to serve 3 months with the balance on probation. You've already served the 3 months, so you get credit for that time. Count two is 5 years. It has to run consecutive to count one. I'll probate that. And then count three will be 5 years to serve 3 months with the balance on probation. That'll run concurrently with count one. So it's a total sentence of 10 years to serve 3 months.
Wow.
Balance on probation. It's a long time.
McBurney, what's going on?
I am not comfortable with just the 3 months in custody. I think this is a low recommendation. I understand why it is. It doesn't mean I have to embrace it. So I'm adding a special condition of probation. You are going to have 10 weekends in jail where you turn yourself in on Friday and you get out on Sunday. It's not going to, well, it'll start this Friday because this is only Tuesday. So you will on Friday the 19th. Let me just finish and then you can talk with your lawyer about it.
Sir, they really have been allegedly, overwhelmed for me. I'm really playing get to somebody and do those, sir.
Oh, okay. Well, let's go to trial.
So I'm reacting to all the things I heard. Aggravated assault with drugs and gun in 2022.
Same thing too.
Marijuana, cocaine, back in 20, gun, drugs, 12 drugs. So,
I think his desire is to explain to you all the other cases.
yeah, that's not helpful.
It's irrelevant.
Right. They are what they are. They are with you. They are part of your profile. There are great things about you. You're a dad. You're a grandfather. You're engaged. Hopefully you're going to get your benefits back. That's why I was initially inclined to say, you know what? I think you got to go back in custody.
Ma'am's not stupid. You get ready to get your Social Security back. You're 43 and look about 97. Go ahead and get your Social Security so I can go ahead and get that lifetime payment check as your wife. Okay. The lady's not stupid. She's probably out here for a check.
For another 3 months. So total 6 months because you already did 3. But when I heard you're trying to get your benefits back, it's not going to help if you're locked up for 3 more months. You also need to get back on your medication. So I'm not interfering with your weekdays, Monday through Friday. But for 10 weekends in a row, you're going to turn yourself in on Friday. You get out on Sunday. That doesn't interfere with your ability to get your benefits back. Doesn't interfere with any of that. If you'd prefer to just do 3 straight months, we could do that instead.
When they start, sir?
When does what start?
He said Friday.
I was going to have it start this Friday. You want to wait 1 weekend?
I'll wait 1 year.
McBurney,
So have it start next Friday? Okay.
I like McBurney, but I mean, come on now. Come on now. It's too much.
So it'll start the 26th. And every Friday then for 10 weeks, you turn yourself in, they process you out on Sunday. So next Friday we'll do that. That's special condition 1. Number 2, what's the name of the apartment complex there? Do we know, or we just say Harwell Road? Do you remember the name of those apartments?
Yes, sir.
What are they called?
Dogwood.
Say that again.
Dogwood.
Dogwood?
Dogwood.
Does your godmother still live there?
No, sir.
Good. You're gonna stay away from the Dogwood apartments on Harwell Road.
Staying away from them.
Good. Keep doing that. You're gonna do that for 10 years. No contact with Miss Caldwell. That's easy. You don't know her. She doesn't know you.
I can speak something to my lawyer.
Yeah.
Good behavior.
What about him?
When you say good behavior, sir, it's like,
Well, I asked Judge about that. He was inquiring about the behavior incentive day.
We'll get there. So no contact with Miss Caldwell. You're gonna need to do 40 hours of community service, and you're gonna need to do those within the first 6 months of your probation. Not 5 years from now.
He's going to end up
first
going
6
to
months of
prison. He's
probation.
not going to do it. I'm
And you'll need to
sorry.
complete an anger management.
I don't believe he's going to do it. I'm not sure what you mean by who's running this. I'm not sure what you mean. Are you talking about Judge McBurney, the voice that you're hearing? Or are you talking about, is this Fulton County? This is actually Fulton County. I'm not sure what you mean, babe.
Management course. That may be part of the kind of therapy you get at Edgewood. You may be able to.
He's going to fuck it up some type of way. I promise you. He seems like a nice guy, and he very well might be, but he's got a lot of issues, and he's got too many issues to overcome them all at one time. This is going to be a lot. And sometimes people are just used to their cycle of bullshit and
do that all in one, and I'm fine with that. I am also going to set a behavioral incentive date for you of June 17th of 2030. That's 4 years from now. That means if you have stayed out of trouble, no arrests, you're doing the things you need to do, because I need to add one more condition of probation, and that's that you take all medications that are prescribed. So if the doctor says take one of the things you mentioned, Seroquel, you got to take it.
You know what, Magic City? He's 33 cycles and he's on the street. He knows how to finesse. He knows how to be humble. He knows how to handle this situation. You see, he talks to his lawyer. He's trying to, you know what I'm saying? Like, he knows how this works. And McBurney is a very compassionate guy. And I like that quality about him, because he's, there needs to be more judges like that, because some are just straight up ball busters. But we need a happy median between compassion and ball busting. You know what I mean? Baby, oh, that's too much. That lady was looking out her window and got shot. You know what I'm saying? Like, just imagine how many times you're being nosy. And not even nosy on a bad thing. You're in your house. That's your window. You can look out a window. But do you imagine looking out your window, you see some commotion going on, and all of a sudden you're calling 911, I got hit? The fuck? And then you find out that this person is basically like a career criminal? That's not right. And McBurney's right to say this is a low ball. He's giving him a very strict probation, I think, on the fact that he's not going to do it. This man is schizophrenic and bipolar, and he doesn't take his medication. Nothing's going to, you know what I'm saying? You got people with high blood pressure who won't take theirs. You think this guy, when he gets into a manic episode, that he's going to think, oh, let me take my Seroquel so I stay out of jail? So I think he's going to be back before Judge McBurney or whoever else. He's going to be back. I don't see him being able to check all the boxes. That's a lot for somebody who's used to doing what they want.
It's not an
and
option.
Also with mental health issues that takes them to another place, right? Because bipolar and schizophrenic, this guy sometimes is, no offense, out of his mind, right? He's not in his right mind all the time. So just imagine when he's in that dark place, what can happen, right? Nesto's cousin. Now, I agree with you there. This is a Nesto. This is another Nesto comparison. Okay. Mm-hmm. Girl, sell his medication. What? Okay. Event will eventually escalate. This is a sad situation. It's sad. I do feel sorry for him because he's in a bad situation. Miss Ma'am, his fiance, needs to pack her shit and go, or whatever, put him out. Cause baby, this is not husband quality material.
I don't think. So if you're prescribed medication, you got to be taking that while you are on probation.
Okay, you got to take it. So that means when he goes to probation, they're going to have to give him some sort of a drug test, like a therapeutic drug test, not a narcotic, not a street drug test, but a drug test to make sure and validate that he is in therapeutic range for his medication. So that's going to cost the state extra money.
But if you've done the things you need to do and we get 4 years under your belt, no new arrests, we can close this case out early. You'll be 47 by then. You should be done getting in trouble.
Yes, sir.
Maybe you and your fiance will have settled down. But life is complicated. Hold on one
Does he have
second.
his hand up? Jesus, help us.
I know you've had some run-ins with the police before. You've been arrested 33 times. I'm hoping you're slowing that down going forward.
Sir. I just finna say I haven't had no conviction since I've been out.
That's good. And I noticed that. That's good stuff.
The fuck? He's actually getting a virtual cookie right now. McBurney, are you handing out I haven't been in trouble since the last time I got out cookies? You know, us law abidings, we don't get shit. Okay.
And it's another reason why I'm all right with just these weekends. I don't want to interfere with your therapy, your recovery, your family, but you're going to be away from them for a few weekends in a row. And to me, that balances these things out a little bit. I think so. I think that makes sense based on what Mr. Bates has said he's been treated for in the past.
That's specifically though. I forgot to mention.
Yeah.
He asked for that.
Okay, so we're going to shift up your probation officer so it's someone who is going to be more supportive of the treatment you're getting. Okay, but that means Mr. Bates is on probation now. Do we need to work through any revocations there, or that's?
He had the revocation in May of last year before he was filed.
Okay, got it. Then we don't need to worry about that. So, Mr. Bates, you may be on probation for 2 cases. It'll be 1 officer. That'll be someone who helps you make sure you're staying current with your therapy and your medication, all that kind of stuff.
Damn near
anything else,
social
Ms. Smith?
worker.
Ms. Cabrera?
Nothing further, Judge.
Do you have any questions, Mr. Bates, about what we talked about?
Oh, no, so about how long would that weekend be?
So you turn yourself in on Friday.
Jesus help us. How long would that be? I think he means 10 weeks, 10 consecutive weeks.
If you show up at 3 on Friday afternoon, you get out.
All summer.
3 on Sunday.
All summer. That's how long it's going to last for. All summer. No cookouts. Friday night to Sunday. No cookouts.
Sunday afternoon. If you show
All
up at
summer.
6 on Friday evening, you get out at 6 on Sunday evening. They keep you for 48.
Okay.
Okay?
That'll work with me.
Hope so. Don't miss any of those weekends.
I won't.
Because probation will reach out to me and then I'll say, I need to give you some straight time. And I know you don't want that.
No, you've been foul. You've been foul a lot.
All right. Well, good luck with things, Mr. Bates. Ms. Simpson is going to talk with you about your reporting instructions, okay?
Yes,
so you can step outside. Don't leave until you've spoken with Ms. Simpson, okay?
Yes, sir.
All right.
Thank you,
Them pills starting to kick in.
Judge.
Thank you, Ms. Cabrera. Hi, Ms. Rios.
Yes, Senator, D'Anthony Owens, I sent an email about him because he missed court, I believe, on the 26th. And it was because his address was not correct in the system. And because he came up here to change his address, but I guess it never went through. He's here now.
What's his case number?
26 SE 001469.
Okay, let me just give a report. Will's back in the courtroom. That's for number 1. Thank you, God. Jesus. Will's back in the court. Melnick I think is standing off to the side. It looks like Melnick is going to be coming up there. Woody's ex-lawyer, Melnick, the one who lost his license for like, did he lose it for like 6 or 9 months? It was under a year. He had some problems with his record keeping or something like that. And then is it going to lunch? Let's see. All right, let's see the next case. But I feel like McBurney's going to be turning his camera off soon or something because it's getting to be that hour. But they might keep the cameras going when they call the court back. I don't know. We'll see. Girl, can you believe it? I didn't mean to lose it on Mr. So-and-so, but damn it. It's like, come on now. That's ridiculous. I mean, I believe in giving some passes and things like that as appropriate, but my God, that's a lot. I mean, we saw the guy get damn manslaughter who killed that lady's son over some sort of dispute. I mean, you know, there have been some sweet deals passed down today. Very sweet deals to people who were not just first-time offenders. So my bad, you guys. Sis wasn't really trying to lose it, but damn it, it's like, come on now. You got to teach folks a lesson at some point because then they're going to come. What's going to happen is something is going to happen, and then it's going to be like, well, why wasn't this remedied the first time? And everyone just doesn't deserve a deal. Some people need to do the time that they need to do to learn a lesson to stay the fuck out of this court.
Anthony Owens. Okay. This would be a Ms. Nix case. I don't know if Ms. Willingham is willing to weigh in on this. I think it's a Ms. Nix case.
What's the charge?
It's a registry violation. I'll give you a minute to look into things. Yes.
Can you give me the case number again? I missed it. Okay. I'll look into it, Judge.
Sure. And so what happened was, so this was an arrest from back in February of 25, so more than a year ago. And Mr. Owens moved, so his arrest address wasn't his address for where things would have been sent, or what is the claim?
Yes, it was not, but he said he came up to update his address, but for some reason it wasn't updated. And then he called my office trying to get in touch with someone because I think someone let him know he had a court date. Who told you? Who told you he had a court date? Oh.
The clerk's office?
No, that's not our office. Our office. And he called.
You have someone named Tina Robinson in your office? That's confusing. Okay. I have two addresses in the system. There's a Crestwood Circle and a Highwood Drive. Louder? Bad addresses. Okay. Your piece of paper has a better address? All right. Do you want more time or are you?
No, I'm good. I was just gonna say, Judge, we would ultimately defer to the court. I mean, it's the defendant's responsibility, and although I understand he's saying he came to the clerk's office, we have no way of knowing that happened, so we will just defer to the court.
Okay. Mr. Owens, is the address that Ms. Rios has on that piece of paper, does the sheriff have that address too? Because of course, the whole reason we're here is that you had an issue with the registry. They have it. Okay. That's probably the bigger issue. Let me check one thing and yeah, so the notice that went out for court went to the Crestwood Circle, and that's not the address that you have, Ms. Rios?
No, you're right.
All right, do you have good contact information in your system now? I don't just mean mailing address, but
Yes, I have his number.
email, cell phone, whatever it would be?
Yes, sir.
Okay, all right. I will lift the bench warrant, Mr. Owens, and you will get a new court date. I guess we didn't even get to, can we do an arraignment waiver now?
Yes, I'm gonna file that.
All right, so that'll take care of you. You won't need to come back to court for a plea and arraignment. We'll get that waiver of arraignment and a scheduling order, and that'll move the case along. Do you have any questions? Okay, so Ms. Rios, you will get to Ms. Nelson, change of address and an arraignment waiver.
Yes, sir.
Ms. Willingham, anything else from the state?
Nothing further.
Okay, thanks for checking into that one. You're good to go, Mr. Owens. Mr. Melnick.
Good morning, Your Honor.
Good morning. So you were suddenly the lawyer for, let's find the case. Mr. Willingham, who is on not a plea and arraignment calendar, but a trial calendar for which I am really searching for a case to try.
Well, Judge, I'd like to accommodate that, but I'm not sure this is going to be the one. I'm still obviously getting my feet wet on the case.
Okay. Any reason you care to share that Mr. Willingham on the eve of trial switched lawyers?
So, Your Honor, I wasn't sure. So just so you know, I've represented members of Mr. Willingham's family for a while. And they'd been talking to me about this case for quite some time. I think they kind of struggled a little bit to come up with the money to hire me for the case. But I know that they have wanted to retain an attorney to look at the case and see if there's a better resolution that we can come up with than what had previously been offered in this case. So, you know, I'm just asking that you accommodate that. I think he's entitled to have an attorney of his choice now that I'm on the case.
He is. It's all about balance. Ms. Smith, anything you want to chime in about the Willingham case?
No, Judge, we've shared all discovery with Mr. Melnick, the offer, everything that we have, he has.
Okay. Is it a particularly complicated case from your perspective? How many witnesses, if this were going forward from the state? Ballpark.
That we would actually call me before.
Okay. Okay. All right. Do you need me to speak with Mr. Willingham or he's good to go?
Yeah, I've talked to him, Judge.
All right. Stay tuned.
All right.
That doesn't mean you need to stick around.
That's what I'm saying. Do I need to stay here?
You don't need to stick around.
Okay.
But I'll be sending an email out and I'm just watching the list shrink. So we'll see what happens.
Thank you, Judge.
All right.
May I make a couple of announcements?
Yes, let's do that. And then we'll take a quick break. So our court reporter can take a break, et cetera. And then we'll pick up the plea line.
So position 11, Mr. Travis, there it is. This will be a trial judge.
Mr. Nelson.
Yeah.
Got it. Okay.
And Judge, just for the record, the state would like to make it clear that diversion is not going to be an option after today. As your Honor knows, if the terms of diversion are completed, the case will be dismissed. That will no longer be the case if Mr. Nelson does not agree to that today.
Okay. I trust.
Diversion, we have to close the business because it's the order that I submit.
Got it. But I'll say the same words. Come on up, Mr. Nelson, so you're not in the distance there. So you have an absolute right to go to trial. I'm not trying to talk you out of it. I just need to make sure you have heard and have processed what Ms. Willingham said. The state made this offer of pretrial diversion, which had some conditions. I'm not sure what they are, but they were shared with you. And Ms. Wood has explained to me that you have politely said, no, thanks. I'm not interested in doing diversion. Is that a fair statement?
Yes.
Okay. Received a.
Oh my God, my bad. I'm sorry. My bad, y'all.
Week. Okay. Got it. Ms. Williams posted. We understand.
Sorry, y'all.
We understand each other?
Yes.
Excellent. Stay in touch with Ms. Wood. I'll be keeping her posted, and I may.
My finger was just a little too ready to do something it wasn't supposed to do. So my bad, everybody. Okay, so we were right here somewhere.
Sure, you
My bad,
have heard
sorry.
and have processed what Ms. Willingham said. The state made this offer of pretrial diversion, which had some conditions. I'm not sure what they are, but they were shared with you. And Ms. Wood has explained to me that you have politely said, no, thanks. I'm not interested in doing diversion. Is that a fair statement?
Yes.
Okay. The state is leaving open the option of diversion through close of business today, which we'll call 5 o'clock, should you have a change of heart. If you don't, then they are withdrawing that option, meaning if you wake up tomorrow or on Monday when we bring in a jury and we start to pick a jury and you nudge Ms. Wood like, hey, you know what? I thought about it. That diversion thing would be nice. That offer is no longer there. You don't get to resurrect it because you had a change of heart. It is an option for you until, I'll call it 5 o'clock today. And Ms. Wood would just need to email Ms. Willingham saying, hey, Mr. Nelson changed his mind. But after 5 o'clock today, I don't know what the state will do, but you cannot compel them to give you that offer again. Do you understand?
Yes.
Good. I thought you did. I just want to make sure. I want to hear it from you so there aren't surprises on Monday. Given that, this case will go on the short list of cases for trial Monday, which will mean you need to be back here Monday morning for jury selection. Ms. Wood will keep you posted on all that, it's the logistics, et cetera. But we need to get that degree of closure because the state has work to do as well. If they're going to get ready for trial, they need to prep their witnesses. And that's why Ms. Willingham is doing the reasonable thing, which is, hey, here's this offer, but I have to close that door today because I need to know that I then am getting ready and it won't be Friday afternoon. I get this phone call saying, yeah, we'll do that diversion. Okay. Any questions about any of that?
Can I take a second to ask one question? Please?
You can ask your lawyer a question.
Woo, baby. Miss Powder Blue Suit is like, now we're fine, we're ready. We ready to rock and roll.
We understand each other?
Yes.
Excellent. Stay in touch with Ms. Wood. I'll be keeping her posted and I may see you on Monday.
All right, thank you.
All right. Appreciate your time. Well, hold on. Before you go, Ms. Williams.
And I mean, at the end of the day, if this guy says he's not guilty and you're not guilty and you don't want no parts of it, I get it. Okay. Okay, sir. We need to keep an eye on his case. I wish him the best. He's not guilty. You're putting in a not guilty. You want to take it to the box. You want your not guilty. You want to be acquitted. I get it. I wouldn't want it either. You know what I mean? Now, pretrial diversion is usually some sort of a program that if you finish the program, there's no charges, there's no nothing. He didn't even want that. So now you're going to take a chance with actually a jury making a decision based on the evidence that the state is going to submit. Yeah, we love it. Go to the box. I never want to see an innocent person convicted. So, you know what I'm saying? I respect if the man is not guilty and he doesn't want any parts of any sort of claiming guilt. I get it. I just think this administration seems to be, if they're not sure about the evidence, then they're not really trying to run you to court. But if they're ready to run you to court, they must have something. And if that something got your name on it, you don't want to be in that blue jumpsuit. I know you don't. You know what I'm saying? We're gonna have to keep our eye out for sir.
Anything else from the state?
Nothing from the state.
Okay, and
Oh,
you
so
don't
he's
have a
gonna be on
conflict
trial
next
on
week.
Monday.
Okay,
Okay.
got it.
Okay, Monday.
Let me provide a couple up. Oh, you have more up. You finish your updates, then my turn.
Miss Laura Charles, she's position 20 judge.
Yes.
I reached out to Ms. Williams. I think she had to go to a different courtroom. But this wasn't gonna resolve today anyways.
Okay, so it stays on the ready when reached list.
Yes.
Okay, are you Ms. Charles?
Yeah.
Great, okay. So it's very similar to what you heard me just say to Mr. Nelson, other than I'm not saying anything. I don't know what the offer was, so Ms. Wood will be telling you about that, or whether the state's keeping the offer open. You will be on this list of cases that are potentially trials on Monday, and Ms. Wood will let you know, yep, you need to be here Monday, or it's not going to be reached. That doesn't mean the case goes away. It means it goes to the next trial calendar. Okay? Thanks. All right. Ms. Jones, Mr. Wooten.
Thank you, God.
Mr. Campbell sent an email about 10 minutes ago saying he's en route from Cobb County. So he exists
Jesus, thank
and he's
you.
heading this way. My guess is
Thank
we
you.
won't get to this till after lunch because we'll take care of people who are here now before we.
Y'all, this is like when you go sit in the court. This is obviously like when you go and you're hoping that the case that you're there to observe is like first or second, and baby, it's not till after. You don't find out till it's gonna be till after lunch, and you sit there all day long. Okay, so it's gonna be after lunch, but he just called Mr. Wooten. But guess what? Lunch, it's 12 o'clock now. We have a lot of time in front of us though. So we still got time. So if you guys are good, we'll keep going. But I think when and if McBurney shuts it down, which they may have already shut it down and took a break, I'm not sure. But when and if they shut it down, we'll shut it down and start a new one, even if it's just for 5 minutes, because we've already been going 3 hours. So we might start up a fresh one, just so we're not going like way too long. Okay. All right, let's keep going. But it sounds like it's coming.
Do go to lunch, but we will be able to have a conversation with counsel present about what's next with Ms. Jones, and he and Ms. Jones can together process the new offer from the state. Okay. So if you guys want to be at ease, just assume we won't tackle Ms. Jones's situation until after lunch. Thank you. Ms. Tembeka, we took a plea with Ms. Chambers. So I got to hear the facts again. She's agreed to testify truthfully if Mr. Thomas goes forward. I know you are still waiting on a police.
So Integrity Matters, did you watch the member live last night? There was like a late night member live, or this morning. I actually have some information about that. And it's in the member live, but there is, you guys know that there is a victim who has been in contact with your girl. And from what I understand, Miss Jones is looking at probation, and Mr. Jones, her brother, I believe, so you already know. So Miss Jones is potentially looking at probation if she accepts it. What the stipulations are, you guys, I do not know. I don't have all that detail, but she is being offered probation, and Mr. Jones could be looking at some sort of, I don't know if it's going to be no pros or what it's going to be, but just stay tuned for that. We're going to see that today. But yeah, there is some, I don't know if you recall the last time that they were supposed to be in court, was it 2 weeks ago? And Will Wooten said that there was some exculpatory information regarding Mr. Jones. So I don't know if there was something that kind of got him out the way, or something that leaned more towards his innocence than obviously pursuing charges. But I think that's what we're going to hear. But I'm also interested in hearing about Kayla and see if they have if there's any additional information about that. But we don't know if they're going to mention that today or not.
Report or a collection of reports. So 2 questions for you. One, do you
guys want to stick with this and keep watching until after lunch? It looks like they have a little bit more to go. Looks like they're going to take a break, and then when they come back from the break, there's another case here, and then I don't know if that's when they're going to go to lunch. We'll see. It looks like
More time to speak with Mr. Thomas today about a non-trial resolution, or that's not where we are at this point?
Judge, yes, I did ask, for my opportunity to speak to them again. I also, asked if we could hold or have our conversation about the Jackson Dental until after I speak with Ms. Smith. I'm very optimistic that the conversation, could result in some.
Great. I will stay out of the way, and when Ms. Smith has that window, which she's about to have in a moment, because we're going to take a quick break, you guys can talk. I think those were my updates that I've received. Mr. King, I know you're ready to go.
Judge, I just wanted to get an understanding. Do you remember when we went through the whole colloquy?
I remember Mr. Moses.
You remember this?
Yeah.
Do we have to go through it again, or is it just a quick, he accepts it, accepts the plea? I was just wondering.
That's a good question. If it is, I think I came down at 18 months.
Correct.
Yeah. I don't.
He wants me to ask for you to, move a little bit, but.
You can ask.
We're ready to move.
Okay. But we would just really get back to that nub of sentencing, because Ms. Rivers took it down. And so the takedown exists, and we would rely on that as the record of the plea colloquy, which was extensive. And then we would just talk about sentencing. I'm good with that, as long as you are. The only logistical hiccup, it's not impossible to overcome, is that today we're benefiting from the good services of Ms. Allen. And I'll just make clear when we go on the record in Mr. Moses's case that this is an addendum in terms of transcript to the record that was made on the day the plea was rejected.
Yes, sir.
Okay, good.
Whenever the court's ready.
We'll do it after the break so that you're done before the lunch break.
Thanks so much.
All right. Ms. Wood, any other announcements from your roster?
I have 2 pleas that we go whenever we're ready for those.
Okay. Anyone who is on bond?
Yes.
Who would that be?
Robin Johnson.
All right.
Who's position 9.
Yep. Okay. Ms. Rios, do you have any bond pleas ready to go?
I only have one who's in custody.
All right. And we will do that. I think then, so you're going to talk with Ms. Smith. So why don't we take a break, and when we come back, we'll do the Moses sentencing and then the Johnson plea, and then we'll see what time it is. Maybe then we break for lunch, and then we'll come back and take care of remaining business. Okay? Thanks. You guys can come back to chambers.
So that's all I have to cover. But yes, I saw the Thursday slide. Are you drawing any of that?
Looks like he's got some students. He's probably got some law students there observing for the day. Okay, so we have time, so we're gonna just take our little time and run through the break. Folk talking. Go there talking all on the Zoom. Okay. Checking phones. Will is sitting there. Will's got time to.
So we're gonna guys.
Okay. Look at this man's. Okay, look at sir. Okay. Hold on. Sir, happy they finally calling his case.
2, but a colleague.
Law students coming back. Okay.
You got any other intern positions I might be able to apply for, Judge?
So I was supposed to have 2, but a colleague is scarce right now, so I'm fostering a couple others.
Okay, so you don't have any more room?
No, the inn is very full.
Understood. My travel schedule is probably, you'll probably write me a bad review.
I know. Where is this guy? He's never around.
I'm always called. Yeah.
All right,
Sir,
Deputy Gordon, when you're ready, we're ready for Mr. Moses.
is Moses on the list? If you guys are looking in the chat, there is a link. I took McBurney's schedule, his docket for today, and I threw it into Excel. That's the link to the Excel spreadsheet. And then earlier, I don't know where it is. I made a PDF. So there was a choice between an XLS and a PDF. Take your choice, because there were so many damn people on the list. I wasn't keeping up. So I did that because I love you guys. Okay. So Mr. Willie Moses, that's what's going on right now. I'm assuming that's Mr. Willie Moses is getting ready to come up. Repeat offender, baby. This should be interesting. And if you notice the time right here on the clock, it says 11:50. So right now we're about 30 minutes behind the court. So by the time we finish here, oh Jesus, they're like, you know, we're gonna handle all this business. Okay, they're trying to handle all that business. Okay. But the last word on the Jones case is one of the lawyers for the Jones case was on their way back from Cobb County. So y'all, I did update on my breakfast. I did finally, Farrah made me some eggs. Isn't she a doll? Girl.
Received a motion to recuse ultimately me, but my staff attorney, because she went to the same law school as it's a pro se plaintiff fighting a pending foreclosure. It's a doomed fight. The law firm that represents the lender, the lawyers from that law firm went to the same law school. And so she said that it's a loyalty club.
Oh, okay.
Yeah.
Mr. Moses.
Yes, sir.
Good to see you.
Good afternoon.
Still morning. We got 8 minutes.
Okay.
So we're going to get on the record in your case, Mr. Moses. Ms. Allen, this is I don't know what calendars you got sent. It's a plea calendar for today as well. But more importantly, it's case 25 SC 004-517. State versus Willie Moses. Mr. Moses is here in court with his lawyer, Mr. King. Ms. Smith is here for the state. And today's proceedings are a follow-on to a plea conversation that we had a while ago, during which Mr. Moses tendered a guilty plea, a conditional one, because he had his final plea rights then. He pled guilty, he understood his rights, he waived those rights, and that was all taken down. So we've got a thorough record of that. This would have been back on the 28th. Is that when we did this? I don't think there was a separate hearing. That was the trial calendar. Did we do it the day of the trial calendar? Seeing if there were any, that was the last court date.
June 16th, 2026 for a plea.
That's today.
Today.
Oh, yes.
Yeah. I almost fell for that as well. Yeah, so we were together on the 28th.
Yes, sir.
On that day, Mr. Moses accepted responsibility for what these charges are. I accepted his guilty plea. He ultimately did not accept the sentence that I imposed. And at that time, he had the right to say no, thank you, if the sentence I imposed was more severe than what his lawyer, Mr. King, advocated for. And I said, got it. That's your call. Since that time, Mr. Moses, I am told, has had a change of heart. I'm going to start again with Ms. Smith to have you state the state's recommendation. I'm assuming it's not different from what it was last time, but let's get all those things out in front of everyone so we've got all our necessary talking points. Then I'll hear from Mr. King. It may be that I've changed my mind, but that would be peculiar. And we'll see where we go. So, Ms. Smith, what is the state's recommendation in Mr. Moses's case?
Yes, Judge, the recommendation in this case is 10 years to serve 2 with the balance probated. The state also asked for the special conditions of probation to be for the defendant to complete an anti-theft course, to have no contact with the victim, and to pay a $500 fine.
This was the stolen Macan. It's some Porsche SUV.
Yes.
Got it. Right. Okay. So no contact with the victim. And what was the last?
A $500 fine.
Okay. Got it. All right. Anything else from the state?
No, Judge.
I believe in making your recommendation when we were last together, you also were willing to withdraw the recidivist notice.
That is correct.
Okay, so this is a non-recidivist sentence that we're handing down, that we're working through, which means most importantly for you, Mr. Moses, is that it's a parolable sentence. Whatever sentence you get, you will be parole eligible. Mr. King.
Thank you, Your Honor. We stated before, we understand what the court's ruling was. We understand and respect you guys' positions, but we want to just reiterate that this is a theft by receiving case, and my client hasn't in the past done any significant incarceration time. And at this point, he's been in consistent incarceration since July 4th of 2025. So where we are now is that he is about to have been completed with a year. And we're just asking for that year to be the year that he has to do on this case. Now, understanding, and in all candor to the court, he had a probation. And Judge Ingram, she revoked that probation on August 25th of 2025 for a year, and didn't give him credit for any time that he served prior to that. So he has to stay in jail until August 25th of 2026, unless so oftentimes we don't know what the Board of Pardon and Parole are going to do.
Right.
But when it comes to the sentence, that's what his sentence is. So we appreciate everybody's consideration, but what we're still asking is that the court give him a year. And that is, he did a couple of days when he first got arrested on this case in 2024. And then when he got arrested on the probation matter, that was a basis of this arrest. He has been in incarceration since July 4th of 2025. So we would just ask the court to give him as much credit as the court can give, but we're asking for 1 year based on this. He's taking responsibility. I told him I was going to, reiterate this to the court, but he also understands that what the court has already said. And if you don't have a change of heart, he's here to take responsibility and move forward.
Understood.
Thank you, John.
You bet. I appreciate your time on this. Mr. Moses, anything you want to add in addition to what Mr. King said, or you echo his sentiments?
I do.
Okay. Understood. Well, I appreciate the perspective of both sides. I did back on May 28th, and for reasons I expressed then, which include the background you bring to this situation. This is not your first rodeo. You've been mixed up with this kind of stuff, whether it's a stolen car or not your ID, someone else's ID. Because I should add, I'm remembering now, it wasn't just that you were driving a car that didn't belong to you. but you had, I think it was a New York ID with your picture on it, but not your name. And it's just sort of a history of you being a little too slick, and it's catching up with you. And it's time for it to stop. Live a different life for your remaining years, and you've got plenty of them left. They will be more complicated, though, if you keep getting mixed up with hustles like these, because judges and prosecutors, not that they are in a league together, but I think both those groups are going to be less and less patient with you getting involved with something like this, and less interested in hearing the latest version of, well, it was a misunderstanding. I'm not sure why I have 4 IDs with different names on them, but my face, or I was just borrowing this car from this person I can't identify. If you were 19 years old, maybe a couple times that would work, but you're the dean of things now, and need to be leading by example. So, Mr. Moses, I am. What is the range for count 2? Is that 1 to 3? I just don't want to impose a illegal sentence for.
Yeah, we don't object to the theft course. We would just ask to waive the fine under the circumstances, Judge.
That's what it's
1 to 3? Okay. All right. So, Mr. Moses, on count 1,
Did they say he stole someone's hard-earned Porsche?
am sentencing you to 7 years to serve 18 months or 1.5 years with a balance on probation. Count 2 is 3 years to serve 18 months or 1.5 years. Those will run concurrently with each other. You will get credit, whether I say so or not, but I am saying so, so it's doubly clear. You're statutorily entitled to credit from that July arrest date of last year, plus another, well, that's that.
I believe who's October? Is it October date?
You do. You have 4 days in October, but every day counts. And so you will get 4 days from October 24, and then many, many days from July of last year through now. Those will all be credited to the 18 months that you need to serve. And again, pardons and paroles may say that's not what you need to serve. It's something less. They can't make it more, but they can certainly make it less. When you are released, you will need to take the anti-theft course and have no contact with the owner of the vehicle. And in lieu of a fine, I'm going to have it be 80 hours of community service that you need to complete during the first 8 months of your probation. That'll be it. I hope you are ready to head in a different direction, but you're your own boss, Mr. Moses. You've been a free agent for a while. There was a DeKalb case. Is that still open? And is that his next destination? Because I know before you got involved, Mr. King, there was some argument that these charges actually have already been dealt with, because they're not. They haven't been. It's a different case.
I represented him in DeKalb on a felony charge that we closed that out.
Okay, that's resolved.
So my understanding is he has a couple of misdemeanors in different places, but no felonies, and I worked that out.
Okay, and I'm asking.
On the same page.
Good. And I'm asking only because I want Mr. Moses to know what his next destination is. If he has holds from other jurisdictions, that's where you'd go next, not to the Department of Corrections. And it may be that just working those out takes enough time that when they add it all up, they say, don't even come here. We're just going to parole you out.
You would expect that he goes back to the Department of Correction, and then if I'm unable to release his hold in Coweta based on a bench warrant, which it should be released because he was in prison at the time, then he's going to be on the street, and we still got to just work on his situation.
With Coweta?
Yes, sir.
Okay. Sounds good. That'll be Mr. King project. Ms. Smith, anything else? Mr. King?
No, Judge.
All right, thank you.
Thank you, Your Honor. May I be excused, Your Honor?
Yes, sir.
Very nice to see you.
Same. Ms. Johnson? Ms. Johnson, you want to come on up, please? So, Mr. Wooten, you're sticking around to engage with, or is Ms. Campbell, he's here? Excellent. Well, we'll talk after we take Ms. Johnson's plea. All right, Ms. Allen, you ready? Great. This is position 9 on our trial calendar. State versus Robin Johnson, 26 SC 000-084. Ms. Johnson is here with
Okay. No sound? I saw someone say no sound, so I stopped the sound. Like, is there really, I don't think that there's no sound. I went to check. Yeah, I know. I was on mute because my dogs were barking. But when I saw no sound, oh, okay. Gotcha. Gotcha. All right, let me.
her lawyer, Ms. Wood,
My bad.
and we have Ms. Smith again for the state. And Ms. Johnson, Ms. Wood tells me you're ready to enter a plea. Is that correct?
Yes.
Okay. Ms. Smith will put you under oath.
Yeah.
Ask you the standard questions. Please answer carefully and let me know if at any point you've got questions or you need to speak privately with your lawyer. Will you do that?
Yes.
Okay. Ms. Smith?
Ms. Johnson, raise your right hand.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Girl, what does she
Okay, you
do?
can lower your hand. Please state your true, correct, and legal name for the court.
Robin Johnson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
20, 9th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So wait.
Ms. Johnson, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you also understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote,
Yes.
the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Ms. Wood, is Ms. Johnson asking to be sentenced as a first offender?
No.
Okay. Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove that you're guilty beyond a reasonable doubt, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Ms. Johnson, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment 26 SC 000084, how do you plead to count 1, aggravated assault, and count 2, possession of a firearm during the commission of a felony?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction, but if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes.
Do you understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Ms. Johnson. Your Honor, if this case were to proceed to trial, the facts would show that on June 5th, 2025, officers of the South Fulton Police Department responded to the incident location of 4375 Cascade Road, Southwest Atlanta, Georgia, also Fulton County. And that location is an apartment complex named Parks at Utah Creek Apartments. When the officers got there, they responded to a shooting call. When the officers got there, they saw 3 people standing at a bus stop across the apartment complex, which one of those people was Robin Johnson, and the other 2 was Takira Griffin and Dakira Stewart. When the officers got on the scene, they approached that bus stop, and when they got to the bus stop, someone ran up to the officers and said, "That's the one who shot my nephew." So the officers began to investigate, and after the investigation, they found out that Miss Johnson went to the apartment complex and engaged in a physical altercation with 3 people of the Joneses family. And the Jones is the victim in this case, but the little boy's family. She got into a fight with one of his aunties. While fighting, the other sister, the other Joneses sister, stepped in to pepper spray Miss Johnson. Once she was pepper sprayed, she asked one of the people who was standing at the bus stop with her to hand her the red purse that she had. Inside of the red purse was a firearm. Miss Johnson got that bag from her friend and took out the firearm, aimed it at the breezeway that people had ran to once they saw that she had a gun. She shot once in the air and then toward the breezeway that the Joneses family and other people in the neighborhood who was outside watching the fight had ran to. She shot one time. It went past one of the people she was fighting, and and a little boy named Chance Jones was shot instead. He was shot in his right leg, in the thigh. He was rushed to EMS. He is doing fine now, but he hasn't sustained any, like he can still walk and things like that. So it's not any permanent damage. So after that shooting happened, Miss Johnson, along with the 2 people who were with her, those people I named earlier, Miss Griffin and Miss Stewart, they ran to the bus stop across the street to potentially try to get away. But simultaneously, South Fulton pulled up, and the aunts of Chance Jones was able to identify Miss Johnson as the one who shot her nephew. Miss Johnson was taken down to the South Fulton precinct, where she confessed that she did have the weapon. She took it out of her purse, and she knew that Mr. Jones had been shot. At that time, she was arrested for the charges we have in front of us. I did get a chance to speak with Jemiah Jones, who is the mother of Chance Jones. She said at the time he was, believe he was 7 years old. She said that since the shooting happened, it's taken a toll on their family. Her child was shot. She said now the biggest thing about him is he's angry a lot. He gets into a lot of fights at school, and she believes that is a result of him being shot, having to go to the hospital, and just having to deal with the pain and memories of that day. I also had a chance to speak with the two aunts that was engaged in that physical altercation with Miss Johnson, and they kind of reiterated what the police incident report said as far as what happened, but as far as how their family is moving along now, it's kind of that same sentiment of having to still live in that apartment complex and dealing with what happened and remembering what happened to their nephew because they were all there at the same time. I spoke with Miss Jones today, Jemiah Jones, who is the mother of Chance Jones, and she told me that she is dealing with a family emergency. I believe she wanted to make a statement today, but she's not on the Zoom. She did tell me that her mom was on the Zoom, who is Chance Jones's grandmother. I'm not sure if she wants to speak, but if she would like to speak, I would ask for her to make a statement if she would like. But as far as the facts and circumstances of the case, that is what the state has regarding the factual basis. Regarding the recommendation in this case, the state is asking for the defendant to be sentenced to 10 years to serve 5 with the balance probated. Regarding the special conditions of probation, the state is asking for the defendant to have no contact at all with the victims or with the victim's immediate family. So those aunts she got into a fight with. We're also asking for the defendant to stay away from the incident location. We're asking for the defendant to also forfeit the firearm. When the officers went to the bus stop, they found the gun laying next to the bushes that was next to that bus stop that was used in the shooting. So we're asking for that firearm to be forfeited and also for the defendant to complete an anger management course. And that is all from the state.
So 10 serve 5, balance probated, plus all the conditions you mentioned.
That is correct.
Okay. And you mentioned that Ms. Johnson confessed to the police, but what you described was she confessed to having the gun and she understood that the little boy was shot, but that leaves this middle ground of, and I'm the one who pulled the trigger that fired the bullet that hit him. She confessed to firing the gun.
Correct.
Okay, so she said, look, I did this thing after I was pepper sprayed. I didn't, sort of like Mr. Bates' situation. I didn't mean to shoot this kid.
Yes.
I was shooting in the direction of these people who had pepper sprayed me.
Correct.
Okay. Did she explain in her statement to the police why she went to parks at Utah Creek to begin with?
No, but when I spoke with the aunts who got into a fight with her, they said that Miss Johnson came to the apartment complex basically looking for them because the aunts had previously got into a verbal altercation with someone named Chucky in the apartment complex. It is my understanding that Chucky and Miss Johnson may have had some type of relations or may have been friends. I heard they met at the pool some days before. So she was looking for them on behalf of Chucky because they had previously disrespected him or got into a verbal altercation.
Okay. Thank you.
And I'm not sure if the grandmother would.
I'm going to check there because there are a couple things that say Jones. Is there anyone on the Zoom call here for Chance Jones who wants to be heard?
Yes, I'm here.
Okay. I'm gonna, if you could turn your camera on, please. Excellent. Well, it was, there we go. All right. If you could tell me, please, who you are and how you are connected to Chance Jones, I would like to hear your thoughts.
I'm Melissa Jones. I'm his grandmother.
All right. I hope the family's okay. Ms. Smith said that Chance's mom was dealing with a family emergency, so I hope everyone's all right today.
Yes.
Okay. What did you want to share with me about this situation from, now we're about a little past the 1-year anniversary.
I'm just glad it's over. I forgave her for everything, so I'm just glad it's over.
Okay. Well, I appreciate you being forgiving. It doesn't sound like Ms. Johnson was trying to hurt your grandson, but when you shoot a gun towards people, you run the risk of something real bad happening, and that's exactly what happened. Fortunately, it sounds like young Chance is okay, that he can run around with his friends. It sounds like there may be some anger issues, but otherwise, is he doing okay?
Yes.
Good. Okay. Do you have any thoughts or recommendations as to how I ought to handle the case?
No,
Okay.
I don't.
Anything else you want to share?
No, that's it.
Okay. Well, thank you, Ms. Jones, for being here, and let your daughter and your grandson know that we're working through this today. Okay.
Okay, thank you.
You bet. Ms. Harvey, any criminal history information on Ms. Johnson?
Yes, Your Honor. 5 cycles. Does not appear to have any felony convictions. The last arrest was June 5th, 2024 out of Muskogee County for battery. There was no disposition listed in this case. There's also a separate arrest from June 5th, 2024 out of Columbus for burglary in the 1st degree and criminal damage to property in the 2nd degree. No disposition was listed for this case. There's a arrest from November 8th, 2023 out of Columbus, Georgia for hijacking a motor vehicle in the 1st degree, also with no disposition listed, and nothing further, Your Honor.
Thank you so much. Ms. Wood,
One moment, Judge. Do you have a question? Okay, we'll talk about that later. Yes, Your Honor. So one of the reasons this case made it this far and we didn't resolve it at final plea is because Ms. Johnson was working on gathering bystander video for me. She did get that to me. I got it to Ms. Smith. And it basically showed us that what the police report says is there was a big brawl outside of the apartment complex that day. It was never her intention for this young child to get injured, but of course that is the problem with senseless gun violence. And we are just fortunate and grateful that it wasn't much worse.
right.
So she is here accepting responsibility, Judge. She's 20 years old. She's from Atlanta. As you heard, she has a 9th grade education. One of the things I would be asking for to be included as a special condition would be for her to get a GED and then also participate in some sort of job corps training, or I'm not sure how probation can work that. She was previously working at Taco Bell and Burger King. However, she's been having issues with the ankle monitor that is still on, keeping her from finding better employment, Judge. We have no issue with stay away and anger management course, and then the no firearms provision. Our request is, so she served 209 days on this case.
Right.
So for count 1, I'm asking for 5 years probation to serve 209 days. Count 2, 5 years probation to run consecutive to count 1. We don't have any objections to weekends in jail, although I understand that since she's currently unemployed, it might make more sense to change that up, Judge, if you understand.
I do.
My direction. And that is our request of the court right now.
Okay. Ms. Johnson, I would like to hear from you if there's anything you want to add, but I have a few questions first. And then if there are things you want to say, I'll certainly hear from you. Tell me what your connection is to Columbus, Georgia. You seem to have some business down there.
Well, I'm originally from Columbus, Georgia, but I came to Atlanta when I was 14. I ended up getting kicked out of my mom and my dad's house. I went back to Columbus because I had got into, it was a case in Clayton County, but it's not anymore. So I was 17 at the time, so I went back home to my parents' house. So basically that's
The home is Columbus.
Yes,
Are your parents still there?
Yes.
Okay, so that's your connection to Columbus, that's where you grew up. You still have family there.
Yes.
When this case is behind you, meaning you're just dealing with probation, do you intend to live up here in the Atlanta area, or are you going back to Columbus?
Well, I intend to live here, but I still have a case open in Columbus that still needs to be taken care of.
Okay, which one is that? I heard about a burglary, I heard about a carjacking.
See, all of those are, I got arrested November 8th. 2024 for the hijacking charge, and they had ped burglary and the other charge on me while I was incarcerated.
Okay.
So all of that is really
It's all tied together,
Yes.
and that has not been resolved.
no.
Okay. Do you know if you've been indicted down there, or are they just charges?
That's just charges. I haven't been indicted yet.
Okay. All right. Do they have a good address for you though? If there is an indictment, would they know how to send you something in the mail so there's not a bench warrant?
Yes.
Okay. You have a lawyer helping you down there?
I have a public defender down there.
That's a lawyer. Good. All right. That's just going to make it more likely that that lawyer learns if there is an indictment, so that lawyer then can reach out to you and you don't miss a court date. Tell me what was going on with Chucky and you and Chance Jones' aunties. About a year ago, last year, this time.
Well, Chucky was my boyfriend.
You say was, he not your boyfriend anymore?
No.
What happened?
I don't communicate with him.
Okay. But at the time, he was your special someone.
Yes, at the time he was. He stayed in those apartments with his mom.
Yeah.
And I went there to see him, spend time with him. And an altercation happened where those females had came up to him and I got into it with one of them, and two other females they jumped me and then they had maced me.
Okay. That's the pepper spray we heard about.
Yes.
And so this is all the same situation. That's when you went back and got your gun and shot in that direction.
Yes.
So you weren't there avenging something that happened to Chucky. It was all sort of at once. You were with Chucky, people had words, you got jumped, you got maced, and then you escalated things.
Yes.
Okay.
That makes sense.
Why did
right?
you have a gun?
That makes sense, doesn't it?
It wasn't mine. That wasn't my purse.
Oh, you knew someone who had one? Like, hey, give me that piece, or?
One of the girls who I was with had it.
Okay. And did you know that she had it, or she said, hey, you should shoot these people?
I didn't know she had it when we on the way there. I didn't know she had it, but I learned that she had it while we was out there and while I was spending time with my boyfriend. That's when I learned that she had it.
Got it. And with that information, you went to her to say, give me that gun.
Yes.
Words to that effect. Okay. All right. Anything you want to add?
No.
Okay. So Ms. Johnson, I'm going to sentence you to a little more time in custody. I'd like you and Ms. Wood to talk about whether you can go into custody today or if you want to have a turn-in date. So you guys should talk about that. But let me tell you the whole sentence and then you can talk about it some more. I have a couple more questions for you. So you're not working right now. The ankle monitor makes it kind of hard to work.
Yes.
I don't think I missed this. Did anyone talk about, do you have kids?
I don't have any kids.
You don't have kids. All right. So you've got family, mostly down in Columbus, but right now, no job and no kids.
No.
Okay. You're only 20. It's okay. Plenty of time for both kids and more jobs. But gosh, it's awfully young to have gotten mixed up in something like this. Ms. Johnson, I find there's a factual basis for your plea.
So I'm just, okay, we're gonna have to find out what she gets. But the grown man with the 30 kabillion arrests gets nothing. And you getting ready to lay it on the smackdown for this little 20-year-old who made a bad decision. Now, was anybody hurt? Because I had to listen to something else really quick. Let's see what she gets, but I'm just kind of like, Judge McBurney, really? That grown-ass man who should have known better should have 5 years, 3 to 5 years, in my opinion. And this girl should be getting probation and some anger management.
It was a traumatic and dramatic time, but the last thing that needed to happen is a gun.
Oh, the nephew got shot. Yes. Okay. Yes. Well, yes, she needs it then. Yes.
It sounds like you were actually able to get away from these young ladies who had maced you, and you could have just left. But you didn't, and made it a whole lot scarier for everyone.
But still, that grown man should have got time. I'm sorry, the lady in the window who I like Judge McBurney. I like him too. That, period. Okay.
Particularly this young boy that you didn't even know. You may have known him, but that's not, I don't think you intended to shoot him, but you pulled the trigger. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. And knowing means you've understood the things we talked about. I think at one point you had a question for Ms. Wood, but she answered that. Do you feel like you understand where we are right now?
Yes.
Okay, and no one's forcing you to enter this plea?
No.
Okay. Ms. Wood, do you authorize someone
That's the little one that's been having the bad dreams and all of that. Okay. Yeah.
in my office to sign the indictment on your behalf and your client's behalf? Ms. Smith, can someone sign for you? All right. Ms. Johnson, I'm going to sentence you on count 1, which is the aggravated assault, to 3 years to serve 1 year with a balance on probation. Count 2 has to run consecutive and has to be 5 years. I'll probate that. So it's a total sentence of 8 years to serve 1 year with a balance on probation. You'll get credit for the 7 months you've already served. So you are going back into custody. The most you'll be in custody would be an additional 5 months. That gets you to the full year that you're going to serve for firing a gun into a crowd and hitting a little boy in his leg. I don't think the state's recommendation is out of bounds. This was scary. It could have been so much worse. But right now you don't have any convictions. You got some mess you got to deal with down in Muskogee, but you come into this young and not having been in a whole lot of trouble. And I'd like to get you moving in the right direction sooner rather than later. I think 5 years in custody might do more harm than teaching you not to do something like this again. But I may be wrong.
And I mean, look, 7 years probation is good because she needs to stay out of trouble. She needs to get back into school, finish up her GED, find something she wants to do, hair, some sort of work in a hospital. That's, but I mean, with her felony, I don't know that she'll get a job in a hospital, especially with the gun violence. So that's probably a no-go on that. I mean, she can make a lot of money doing hair, braids, nails, esthetician. There's lots of jobs that she could get, learning a skill or a trade. But she's going to have to stay out of trouble for the next 7 years.
But I left a lot of probation so that if you do mess up, we can just use that probation as prison time. So I'm hopeful that while you're on probation, things go smoothly. Just know that if they don't, I will remember what this case was about and that I sentenced you more leniently than what the state asked for. And I won't make that mistake again if you get into a situation like this. And by that, I don't mean you get into a fight. Someone may jump you. You need to not pull out a gun and shoot into a crowd. You need to walk away from that situation. Easier said than done, but that's what you're going to need to do in the future. And again, I'm just so grateful that Chance is walking and talking, because we would have been talking about something real different if that had hit a femoral artery, he bleeds out, then we're talking about, is it life for Ms. Johnson or 30 years to serve? And we don't need to worry about you having kids because that's not going to happen. Special conditions of probation. Number one, most important, is that you have no contact with the whole Jones group. It sounds like you know some of the aunties of Chance Jones, but you know who I'm talking about, that family. We met grandma. Mom couldn't join us, but no contact with Chance, anything like that. Do you still have people you know who live at parks at Utah Creek?
No.
Okay, because number two is you stay away from that apartment complex. What makes it easy is if the Joneses are still there, it's going to be easy to have no contact with them because you're not going there. But if they've moved, you don't reach out to them on social media saying, I had bad aim this time, I'll be better aim next time. It's nothing. You don't communicate with them. You'll forfeit the gun that was seized. I appreciate it may not have been your gun, but you can't seek to recover it. If the young lady who owns it wants to step forward, say, hey, I want my gun back, we'll work through that. But it's not for you to collect when you're done with your sentence. And you need to get your GED. You're very well spoken for someone who stopped at 9th grade. So I want you to get your GED. It'll help you with employment in the future and whatever else you hope to do. Now I need you and Ms. Wood to talk. I will let you know that I had a bad experience very recently when I said to someone, you can report in a little bit. And I don't want to put that on you because it wasn't your bad experience, but it had gone well until the last person I told you can come back in a little bit and report. Everyone else had shown up on time when they were supposed to. I'm going to give you that opportunity if you need it. But that's just a few days to get your affairs in order. It's not, hey, I'll be here in August. But you may want to say, look, let's just get these remaining months going. Talk with Ms. Wood, and then let me know what your preference is, okay?
Okay.
All right. You're welcome.
Okay. So, you heard that, right? He said he had a bad experience recently telling someone that they could turn themselves in later, right? You hear that? Okay, let's get into it. If something's getting ready to come up.
While they are talking, we'll go off the record and turn, speaking of situations where someone didn't turn herself in. Ms. Jones, now that your lawyer is here, Mr. Campbell, Mr. Wooten let me know that there was a revised offer from the state. He didn't say it was better or worse, just revised. But Ms. Jones is in theory, there are two cases still standing. Ms. Brown's case isn't getting better for her. But we do need to figure out what we're doing with Ms. Jones's case.
You heard him just say Kayla's case is not getting better for her. Just listen, because just listen.
Yes, Judge, and
So this Miss Jones is the mother, co-defendant / mother, right? So you see the lady standing up in the back?
I did receive the offer on Friday, and after seeing the order for the co-defendant, light bulbs going off with Ms. Jones. I do have some mitigation to provide to Mr. Wooten that hopefully will help her some. And she's working on getting those documents. We're going to go once we leave here today, and I'll provide those to Mr. Wooten as soon as I can.
Give me an example of something that your client has told you she hopes to get her hands on to get to you, to get to Mr. Wooten. Bank records, okay. And Mr. Wooten, was bank records the kind of thing that Ms. Moorman got to you? And they don't need to be the same, but what I don't want to do is say, hey, we'll see everyone in a few weeks when whatever Mr. Campbell might get from Ms. Jones isn't going to be a needle mover for you.
So, yes, Judge, it was bank records from Ms. Moorman, but that was a very different situation. Without going into all the facts of the case, Mr. Jones was never physically present, and we had an issue proving his knowledge and intent based on what was provided to us, and felt that we could not necessarily overcome potential reasonable doubt.
Okay.
That's not the same situation for Ms. Jones. She was physically present for some of the transactions based on the testimony of Kayla Brown that frankly made things worse for Ms. Jones, because I believe it implicated her even more and demonstrated more of her knowledge.
But knowledge and mere presence doesn't get you to being a party to the crime. I mean, I know you know that, but so maybe this is where the bank records help, or?
I don't know that it would move the needle for me. I'll also say to the court that the new recommendation is a probated first offender recommendation. So I don't know how the needle kind of is as far as it can go.
Got it. Given, I'm sorry to interrupt you, but given what you learned from Ms. Brown's sworn testimony, that links Ms. Jones to some of this situation, being physically present, aware of it, et cetera, and then what you heard from the victims, it's not a Mr. Jones situation, which is, we're just going to carve you out of this. That's what happened. But it is as low as it can go, first offender, probation. If you can demonstrate during the course of this sentence that this was not the normal operating situation for Ms. Jones, it's like it never happened. It's not on your record to begin with, and it's not on your record to end with.
That's right. I can say, of course, open to look at what they've got, open to continue negotiations as it relates to some of the special conditions, restitution in particular.
Sure.
Conversation, but as far as the recommendation itself, I don't see it changing.
Okay.
Only thing I would add, though, Judge, is that
now that Ms. Brown has entered a plea and has testified, and I believe that that testimony helps our case, she's a witness now. And so,
Ms. Brown is a witness?
yes, I would call her to the stand, absolutely. I think I have to, if we proceed to trial. So I mentioned that to say that, now I did learn that she is now out of the hospital as of this morning.
Dun dun dun. He said he learned she is out of the hospital as of this morning. So why has she not turned herself in? You were due to turn yourself in yesterday. So you're out today. Why didn't you come straight to court?
Proceed to trial. So I mentioned that to say that, now I did learn that she is now out of the hospital as of this morning. I don't know where that leaves things as far as us getting a subpoena in her hand when there's an arrest warrant out there. So I don't know where we go. I think the first step has to be getting her into custody in that chain of events. So I'll just bring that up all to give the court some context as to where we are with our state's ability to proceed to trial. We intend to go to trial if we need to. It's just she's kind of a keystone witness that we need.
Got it. And when you're talking about trial, you would be ready to go on Monday?
There's a few weeks. So knowing that Ms. Brown was going to enter her plea, we kind of put our witnesses on hold. I think it's a trial that would take more than a week based on the number of witnesses.
Even if the trial is of Ms. Jones and not Ms. Brown?
Yes, I think because it's a RICO, we got to put the whole case.
Okay.
And provide the whole story.
I got the sense that the victims were pretty motivated to participate, so I don't know that you'd have trouble getting them here.
I can't say for sure just because we did not immediately have a discussion about everyone coming in for trial.
Sure. Okay. Well, let me throw one more fact in there as Mr. Campbell, you and Ms. Jones are thinking about what's the best way to move forward. I will have jurisdiction over this case through the last day of June. After that, it goes to a different judge who doesn't know anything about the case, is going to have a steep learning curve. And I'll let you talk with Mr. Wooten about whether that judge is generally a more sympathetic judge or less sympathetic judge. But it will be a whole new can of worms as to how everyone navigates it. So insofar as there's value to familiarity, then there's a time frame for things to happen. I am available any of the days between now and the end of June for a plea. So if we don't try it next Monday, and that seems like it would be a bit of a crunch to do that, then if it is resolvable, especially with the state's offer, the time to do that would be before the month ends. And that has nothing to do with the state. It's just dockets being handed off between judges. And that switch might not be advantageous, but you'll need to sort that out. So I think I understand where you all are. And I share that only because that would be, hey, don't just put those bank records in the mail, put them in FedEx 20-minute delivery kind of thing. Because I'll check in with the two of you after a bit. I don't mean today, but in a few days, maybe next week, saying, where are we? Is this something that can be resolved? It's just probably more efficient and smoother if there's a way to close everything out while it's still under my purview rather than my successor's purview. For what it's worth. Okay. Ms. Jones, do you have any questions about what we've been discussing? For me, obviously, Mr. Campbell is your go-to guy and can give you good advice, but do you have any procedural questions for me? Okay. Your daughter is home with you or home at her place? Okay. All right.
I didn't hear her say one word or the other. Hold on.
If there is nothing, all right. If there is, okay. Daughter is home with you or home at her place? Okay.
Girl, I didn't hear.
All right. If there is nothing else,
Who's Miss Jones? The lady standing in the back. The lady sitting in the box is the prosecutor, right? So there's someone standing up in the court. That's Miss Jones. I would assume I mean, no one else should be standing up. But the lady in the other side of the screen, just to clear for anybody who's not aware, the lady who is sitting in the witness box is one of the prosecutors. They're off the record. So if you're just coming in, they're having I'm sorry, my dog just started barking really loud. They're having an off the record conversation. That's why Wooten is not standing at the podium. I think they just saw Miss Jones's lawyer come in and oh God, my dog is barking. They're having a off the record conversation. Miss Jones's lawyer came in while they were doing the plea negotiation with the young lady who shot the little boy, and they interrupted that moment to have this moment. So they're not even on the record right now, but that's Miss Jones standing up.
then I need to see Mr. Wooten and Mr. Hansel, and then we can be done. You don't need to, it's not about your client, but we will check back in with you. And why don't we break for lunch? We will.
So McBurney, so you guys know, McBurney, I think, is going to family court as of July 1st. His assignment is changing. So what was he referring to? He's still a Fulton County judge, but the judges move assignments from time to time. Or I don't know how long the rotations are, but his rotation is going to family court as of July 1st. So he's out of there. So when he was saying, there is some benefit to familiarity, at the end of the day, he's like, basically, I think he's saying, let's get this taken care of now. Let's either get it to trial now or let's do whatever now. Because at the end of the day, you might have a judge who comes in and is not playing with y'all. You know what I mean? May have a whole different philosophy of how to do things. And that's it. That's all.
Reconvene. We'll try to start as close to 1:30 as we can.
Before we do that, that's fine, but can we finish off Ms. Johnson before?
Yes. Sorry, I forgot. We need to, yes, yes, of course. Are you guys able to hold on for 2 more minutes? Okay. Ms. Johnson, come back up, please.
I wonder if they're going to send the sheriff, because they already have a warrant for her arrest. I wonder, is Kayla going to get the 15? Because I think the fact that she got out of the hospital, didn't, whatever she decided to do the minute that she got out of the hospital, if she is not in the custody of her attorney, taking a shower, packing her bag, and maybe she's waiting for her mom to get home. I don't know who's supposed to have custody of her children, but at the end of the day, the fact that she left the hospital and is wherever she's at, not en route to the court, may be giving her 15 years, because he told her, if you're not here, you're getting 15 years. And she wasn't there yesterday. She got out today. The excuse is, I was in the hospital, but you're out of the hospital and you didn't come straight to the court. I don't know. It sounds like she's going to get 15 to serve 15, because it doesn't sound good, because he's saying, he's identifying it and being snarky as a bad experience and all that. It sounds like to me she getting ready to get it.
All right. Ms. Wood, did you have a chance to speak with Ms. Johnson about her preference of going into custody today versus really, really soon?
Yes.
And?
We spoke about it. She was requesting if she could turn herself in on one of these court dates that we have in the next couple of days.
Okay.
So she can get everything lined up.
So I'm good with, will you be here for the plea and arraignment calendar on Thursday? Yes. Okay. Does that work for you, Ms. Johnson, Thursday?
This Thursday.
This Thursday. When you said next couple days, I took that literally. Did you not mean literally?
A couple, so we have that one and then we have, I guess, Monday, whatever happens.
Yeah, I mean, it would also be Monday. Would you prefer this Thursday or next Monday?
Next Monday.
Next Monday.
Yes, I had to call my mom. No, my family is in Columbus. So
Okay.
I have to get all that in order.
Okay. So here's how it's going to work. You need to be here next Monday, 9 a.m. like you were going to trial. You're not going to trial. Don't show up with lots of folks. Don't show up with lots of belongings. Whatever you're wearing, it should be the kind of thing that if you end up never seeing again, that's okay. I'm not saying you won't see it again, but it'll go into property. And I don't know how likely it is that you get reunited with it. If you are not here by 9:30 on Monday, and Ms. Wood isn't here saying, no, look, she's coming. I got her right here. She's on the phone. I'm going to impose the sentence that the state asked for. So right now, it is the 1 year to serve followed by some probation. If you are a no-show on Monday, then I'll impose the 10 to serve 5. That's the value to you of being on time on Monday. And between now and then, not disappearing on this, okay? You got the ankle monitor, so disappearing will be complicated. Don't cut the ankle monitor off. Don't stop the charging of the ankle monitor, because I'll be reaching out to Second Chance saying, hey, over the next few days, let's keep a close eye on Ms. Johnson.
Okay.
Make good decisions between now and Monday, okay?
Okay.
Any questions about any of that?
No.
All right. You'll get reporting instructions about probation when you are released from custody. But if you're staying in Fulton, you'll be reporting in Fulton. If you're down in Muskogee, you'll be reporting down in Muskogee.
Okay.
All right. Anything else, Ms. Wood?
No, Judge, thank you.
Ms. Smith?
Nothing further, thank you.
All right. Appreciate it. So for those of you in the gallery, we will get to all the other cases after lunch. We're going to break for lunch. We're going to try to start up about 1:30, maybe more like 1:35. I got to get everyone fed. But we'll pick up everything from there in whatever order you all arrange. Mr. Jones, I haven't seen yet, Attorney Jones, but he said he was going to be here hopefully by 12:30. He didn't quite make it, or he may be talking to his client now, but he did affirm that he would be here.
Thank you, Judge.
Okay, you're welcome.
Judge, I let him know that you wouldn't be taking the bench back till sometime after 1.
Excellent. Good plan. Thank you. I will mute things here.
Don't mute, Bernie. Don't do that. Oh man, this is gonna be the real tea right here. Oh, they getting ready to send them folks to her house. Kayla, if you're watching, baby, you better call your attorney and get him to run you downtown before they come to your house. I feel like whoever Will is sitting next to is a law enforcement person. They getting ready to send the sheriffs. They getting ready to send someone over there. You were supposed to be there yesterday. You got out the hospital this morning. You should have ran to the house, took a good shower, put on a tracksuit, and got in the car and met your attorney up at the courthouse before they are sitting here doing all this. Yeah, I guess because the crime isn't like, she's not like a serial killer or anything. They probably, or whatever. I know that they do that. We've seen that. Where they'll put the cuffs on you in your bed. I don't know. I've even heard women who are delivering have had handcuffs in the delivery room. Okay. So yeah, that can happen. He put us on mute, y'all. Okay, so Miss Jones was excused. Mr. Adarin, we don't know what's going on with that. So I think they're going to be back after court. Excuse me. I think they're going to be back after lunch. Okay. Look at Will. Ma'am. Baby, you know, I mean, how much do you want to bet her mother's not like, baby, I'm on my way. Mm. Okay. All right. So look, guess what? They went to lunch at whatever, what time is that? 12:40 something. And guess what? It's right now it's 1:20. Bougie, can you text Will to tell him that Piggy needs more info? You know, I can't. I don't. Yeah, I would love to. I would love to. You know, he doesn't speak on current cases, not to mention I'm over here on live stream broadcasting about it, girl. I know you're joking. Girl, but I'm not. You know what I'm saying? Like, girl, look, oh, look at the courtroom still up there on top. Okay, guys, let's do this. Y'all, what a fun court morning. Look, at the end of the day, we're going to miss McBurney over there in Superior Court. He's going to family court. This is what we're going to do. We're going to shut this down. We're going to keep it very cute right at 4 hours. Of course, girl. When we go live over here. Okay. It's been a great morning. Make sure to hit the thumbs up for me, please. It's much appreciated. Hit the thumbs up. Let me check and just see. I did not know I had any fan funding, so thank you guys. To Tam Tam, thank you so much. I think Tam Tam became a member or renewed her membership. So, boom. Okay. Thank you to Tam Tam. Integrity Matters, thank you for the jewels. Okay. And Scorpion, thank you for the jewels. Okay. Thank you for doing that. I appreciate it so much. Y'all are amazing. Now, if I see Will, we'll come back. Just give me like I'm gonna take a break. I'm gonna get up. I've been sitting on my ass for 4 hours. Let me let my dogs out, walk around a little bit, stretch my legs, and we'll come back, even if it's just for a minute. It seems like something is happening. I don't know if I would imagine Adarin's lawyer needs to be back. So this is what happened yesterday. We have a victim who's been in contact with Bougie Gang, me. Okay. I got informed yesterday that I got informed by the victim who stated that court was happening today, number one. Number two, that Miss Tanya was going to, they did give her a deal. She has not accepted it yet, but she's been offered a deal. And this is what the deal would be, which would be probation, but she would also have to admit guilt. Now, that might sound like, well, that's not that bad. Well, I mean, admitting to some felonies can possibly cost you your job. It can cost you your career. It can cost you a license. I don't know what this woman does for a living, but it can cost you some things. So I'm not saying to feel sorry for her. I'm saying maybe she's trying to weigh her options. And I think she's trying to get a first offender, but I don't know all of the particulars, because you heard what I heard and they didn't mention all that, right? Number two, Mr. Jones. And if she chooses to not accept it, you heard Will say he has enough information to prosecute, as well as the testimony from her daughter is now going to make her daughter a witness. Hello? And he felt like her testimony gave even more information to the potential prosecution of Miss Jones, her mother. Okay? Did we all hear that? So number two, Mr. Adarian Jones, they said, which is what I heard them say, is that they were going to, I think, no pros because there just isn't enough strong evidence. There's not enough strong evidence to secure a prosecution. And because they're not strong with it, They're not going to play with it. Okay. I'm just, okay. So I think based on that, but keep in mind, when I looked up Mr. Jones, baby, I think he's been in some sort of scammery trouble before. So I feel like they're probably going to null process. And if he wants to play again in Fulton County, then he can get it, because I think will probably null process, put it to the back burner. And then if you want to play, then we've got these other cases that didn't have as strong of evidence that we can merge with any potential new shenanigans in the event that happens. Okay. And then what do we have? We have a pattern. We have a pattern. Okay. Which is Will's specialty, the pattern of behavior. And that's right up in his wheelhouse. So I think he was getting ready to let Mr. Adarin go, but they're not at court. Why are they not at court? We don't know. Okay. So I feel like something could be happening. If we see Will when McBurney comes back, then we know that he's got something else to talk about. Plus, Dontavius, the man who wanted to change his name to Sean Carter, who was in trouble for some other stuff, girl. I forgot what his charges were. Mr. Dontavius, right? He's supposed to be in court too. For what, baby? I don't even remember, because that was like, I probably read 25 cases since then. So I don't know. I have to go and refresh. You know, they say, if I show you this document, will that refresh your memory? Yes, it will. It will. So I'm gonna have to go get refreshed. So guys, let's take a break. Let's shut this down. Let's take a break. Let's relax for a minute. Okay, let me let my dogs out, and let's shut this live down, because it's going to be way too long. Nobody's going to come watch it. They're not going to come. They're not going to watch. They're not going to see. It's too long. So, okay. That was interesting, though. I felt like that was a good court morning. I enjoyed it very much. Isn't this crazy? What I'm going to do in my edit is I'm going to take all the Kayla parts, the bits and pieces, and we'll just put it together. Which right now there's just that one part, but it's the snark of McBurney saying he's done that and it's worked fine up until recently. Someone decided to play his kindness for weakness. Okay. Dontavius, Sean Carter, right? Okay. If you are wanted and you just got out the hospital, she should have took her shower and got her clothes on, and her lawyer should have driven her straight to the courthouse. But in theory, if you needed to go home, drop off your jewelry, go kiss your kids, go eat a meal, pick up something to go from the Waffle House, or stop over there at, Toastery. Girl, go get you some Alfredo, pick up a lobster tail. I don't know what you need to do before you go check into the clink for 5 years, but baby, it's not go home and take a nap. Okay. It ain't on some go home and rockabye baby, because I think they getting ready to send them boys over to the house. Okay. When are we coming back? I don't know, like 20 minutes or so. I just needed to get a break. I've been sitting on my butt, and so have some of you guys. I'm sure you guys have been walking around, exercising, running to the bank, all of the things. Sis been sitting on her ass for 4 hours, and my butt's tired. When are we coming back? Let's say no later than 2. Okay. Let's shut it down now. I'm going to have the live playing in my background. And as soon as, if something is happening, baby, we're coming right back. Okay. Even if we just come back for like 10 minutes just to say, looks like it's over, I'll let you know when I know something, because they're in contact with the victims, and I've got a good pipeline with this victim. And baby, she, you know what I'm saying? Like, I will know something. Cause if I couldn't really say too much because, Will is on, notification gang bushes types of thing, you know what I'm saying? So I didn't want to talk about my information, which I just did. So, I have enough to shift, but okay. You have enough to shift butt sides. Baby, it's time to walk it out. It's time to walk it out. Put some steps in for a minute. Okay. All right, you guys, let's see what's going on here. Let's advance. Girl, before we know it, they're going to be back. Okay. I just advanced it. Nobody's in the courtroom. Courtroom is empty. Okay. Courtroom's empty, and I'm going to go let my doggies out. Okay. All right, boo-boos. I'll be back. I'll put up a live so that all we have to do is check in. 2 p.m. it is. I'm going to watch The Polygamist till what's the polygamist? The polygamist who? Oh, I appreciate you too. Okay, I appreciate y'all very much. Yeah, get outside, touch grass, see air, all of the things. Okay, you guys. Like I said, I'm gonna shut this down real quick and I'll put up another one. It's gonna be vague like this one because I didn't want to do and say too much. So it'll be another one. So just come back in like 5 minutes and look for the live and just hit the notify me button. Okay. All right, you guys. Toodles.